Good morning. I'd like to welcome you to this Wednesday, March 6th public hearing of the Judiciary Committee. If there are no comments from the chair and the ranking member, we're going to get right into it. We're going to begin with number one, which is Charlotte Reesing. Good morning. You may sit down and you will get your 3 minutes. Let me just say for everyone, we try to be fair to everyone. So at the end of your 3 minutes, I'm going to ask you to wrap up. That does not mean to just continue reading your testimony. I will try to be nice and then less nice if you keep going. All right.
Hi, my name is Charlotte Reesing. I am the Government Affairs Manager at Center for Policing Equity, a research and action organization that uses science to identify and reduce the causes of racial disparities in public safety. We've worked with law enforcement agencies across the country, including Newington, Watertown, and Clinton, Connecticut, to analyze racial disparities and recommend changes to address those disparities. Connecticut, like many places in the country, faces a dual public health crisis of traffic crashes and racial disparities in traffic enforcement. HB 5324 addresses both, and we urge you to support it. This bill, which is based on recommendations by the Police Transparency and Accountability Task Force, will help police improve and prioritize road safety by allowing police to focus on infractions that actually cause crashes and fatalities, like speeding and impaired driving. 7 equipment and administrative infractions that are not significant causes of crashes, such as tinted windows, a single headlight out, or a slight obstruction of a windshield, think fuzzy dice, would be reclassified as secondary, meaning that they cannot be the only reason for a stop. The other 8 infractions addressed in the bill are either de facto secondary statutes already or are clarifications of law. That still leaves almost 700 motor vehicle infractions on the books. This is a more moderate but important approach to modernizing traffic code than we've seen in other jurisdictions. We've seen this in Virginia, Philadelphia, and San Francisco. Police chiefs in Connecticut have recognized the need for reform and found success. When the chief of New Haven reprioritized traffic enforcement to focus on dangerous driving after finding racial disparities in enforcement, crashes dropped by 15% and crime dropped by 5%. Not only would this bill improve traffic safety, it would also improve racial disparities in policing. Anyone who drives breaks a traffic law, but the evidence is clear that in Connecticut, Black and Latinx drivers are more likely to be stopped for administrative and equipment infractions like the ones addressed in this bill than white drivers. The preventable deaths that stem from traffic crashes, as well as routine traffic stops, demand the evidence-backed change that HB 5324 sets forth. Thank you.
Thank you. Is there a question from the members of the committee? Senator Kissel.
Good morning. Thank you, Chairman Winfield. I had supported this concept in session, I think it was last year. I don't believe the bill made it through the House. One of the things that I've heard in the meantime from some of my law enforcement officials in my district is that, well, if you're going to create a second tier, why not just get rid of those laws? If we can't pull people over for those laws, then I guess the legislature doesn't care enough about them. So why don't you just take them off the books so that there's no misunderstandings regarding any of this? Obviously, I think their position is they disagree with other law enforcement officials that have sort of embraced this concept. And I'm just wondering what your take is on that.
Yeah, my take is that this is a way to modernize the code and shift police attention away from these types of infractions while still allowing them to be ticketed as secondary offenses. I mean, basically, we have other types of infractions, right, that are secondary. I know Connecticut only recently sort of created the second tier, but other states have been doing it for a long time and found success. It keeps offenses in the code. So the legislator can decide to take these off the books if they so decide. Other states are looking at modernizing their traffic code by going through and removing infractions entirely. And that would be something that we would support as well.
So your position is if we decide legislatively to leave them on the books, that if a law enforcement officer pulls someone over for a non-secondary offense, but then in that stop determines that there's these other issues, they can still charge the individual. You're just saying that the primary response to the primary goal of pulling someone over should be these other violations, not these secondary violations.
Yes, that's correct. We want police to be able to focus on the infractions that really cause traffic deaths and crashes.
And obviously in Connecticut right now, there's a huge concern regarding wrong way traffic accidents. And I think the head of our state police said there's going to be an enhanced traffic stops on highways. I think back a few years ago when I served on the transportation committee, there was an individual who had done a study through the University of Connecticut who indicated that during the pandemic, actually, there was so many people working from home that there was less traffic on the roads, and therefore traffic speeds went up. And now that the pandemic, got knock on wood, is hopefully long behind us in the rearview mirror, but those traffic speeds haven't concomitantly come down. So now we have a lot of what I would say reckless driving, fast driving, and so we need better enforcement regarding that. You said that there's empirical studies in other jurisdictions, and I don't know what within Connecticut, you had mentioned 3 communities that show that this switch has enhanced enforcement of other more deleterious and dangerous violations. And if you do have those studies, if you could provide them to us on the committee, that would be helpful when I sit down and talk about this issue with some of my less enthusiastic law enforcement professionals.
Yes, absolutely.
Thank you so much. Thank you, Chairman Winfield.
Thank you, Senator Kissel. Is there comment or question from other members of the committee? Comment or question from other members of the committee? Seeing none, thank you very much for joining us this morning.
Thank you
Have a
for your
great day.
time.
Farrah Garland.
Distinguished members of the Judiciary Committee, good morning. My name is Farrah. I am a disabled queer advocate and activist who has served my community in local and state positions for many years now, working for equity, access, and equality. Most of my work is in disability rights, but the intersection with disability and policing is neither small nor insignificant. So here I am. HB 5324 is a common sense measure that will not only reduce racial disparities in traffic stops for non-safety related offenses, but it will also allow law enforcement to focus their resources on actual dangerous driving behaviors. It would make roughly 5 categories of offenses into secondary violations, like tinted windows, single broken headlights, improper license plate displays, mirror obstructions, and extends the grace period for failure to renew driver's license and registration. In 2022, the Connecticut Racial Profiling Project analyzed 5 years of crash data, and they found that the secondary violations proposed in this bill do not contribute to motor vehicle crashes. This is included in my written testimony. In Hamden, police were using pretextual stops in a primarily Black neighborhood, and after shifting enforcement tactics to focus on dangerous driving behaviors, they saw a 5% decrease in crime. And as my previous speaker and colleague mentioned, in New Haven, when the police chief reprioritized traffic enforcement to focus on dangerous driving, they found a 5% drop in crime and 15% reduction in accidents. HB 5324 is based on recommendations by the Police Transparency and Accountability Task Force, which includes members of law enforcement and community organizers. It is not only common sense, but similar laws have already been adopted by Virginia, Philadelphia, Pittsburgh, and being considered by California, Washington State, and several others. In conclusion, I am asking today that the committee please support HB 5324 wholeheartedly. Thank you so much for your time.
Thank you for your testimony. Is there a comment or question from members of the committee? Senator Kissel.
Thank you, Chairman Winfield. Thank you for testifying. I guess I should be more on top of all these issues, but when you first spoke, you said that you are a representative of the LGBTQ community. And I'm just wondering, in my years on this committee, I don't recall a lot of cross advocacy. And I'm just wondering, does this secondary stop initiative legislatively have a disproportionate impact one way or another on the LGBTQ population out there? And I'm just wondering for my own edification, because I've heard different information regarding this, what does the Q actually stand for in your observation?
Both excellent questions. To the second one first, Q is for queer. It can also stand for questioning. Some people prefer that, but most of us, myself included, use Q for queer. And to the first question, as far as the intersectionality of the queer community and traffic stops, yeah, there definitely is an impact there, but it's definitely not as strong as it is for people of color. That's a much more significant demographic that's impacted. But both disabled folk, which I am, and queer folk, which I am, are much more tend to have much more difficult interactions with law enforcement than cisgendered, heterosexual, and able-bodied and able-minded folk. So any way that we can reduce, unnecessary interactions with law enforcement that can turn, stressful, violent, or especially for people of color, deadly, such as, oh my goodness, what was the name of the fellow in Connecticut that passed a few years ago? But it's really, people of color are affected the most. Disabled people and queer people are definitely affected. But that's often an intersection. They are also often of color. So I don't want to speak over that community. I'm sorry, I have a young cat.
No,
She
that's
wants to be
okay,
on
because
screen.
I was just seeing that cat's tail like going crazy, and I thought it was like my eyes or something.
Oh yes, no, she's young and also very eager to be on camera.
Always like to encourage participation even with kids.
That's
So
right. We gotta start them young.
I appreciate your helping me with the Q portion of
Mhm.
LGBTQ. That in your opinion, it's predominantly queer, but sometimes it became questioning,
Yep.
because I've been in like places where that's sort of been debated, and now I guess both answers are correct. And
Yeah.
it's interesting to know that that the community that you represent also has some concern regarding these secondary traffic stops. I just want to say that all the police that I have spoken to, I have the utmost respect for. They're highly esteemed professionals, and it's a tough, tough job. And I think it gets harder as the days go by. But again, the testimony that I heard last year, and that I'll receive more information this year, that it's just a reallocation of resources to try to address those violations that pose the greatest public risk, at the same time minimizing the deleterious consequences of pulling over people of color, or now, as you testified, people in disability community, or various sexual orientations. I think that's something that we should address in an even-handed manner. So I appreciate your testimony, and
you.
thank you so much. Thank you, Chairman Winfield.
Thank you, Senator. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us this morning.
Thank you.
We'll next have Ronell Higgins, Chief Higgins. You can take your seat. Good to see you. Good morning.
Good morning. I am joined this morning by Attorney Sarah Carwin, counsel to the Commissioner. I am here this morning in support of the Governor's Bill, House Bill number 5055, an act strengthening police data reporting requirements. The Department of Emergency Services and Public Protection supports raised Bill 5055 enact strengthening police data reporting requirements. The integrity of our state's law enforcement records and the accurate input of information into these systems by law enforcement officers is of paramount importance. All stakeholders in the criminal justice system, from police officers, prosecutors, judicial officers, the press, researchers, and citizens, rely upon these databases for the fair and orderly investigation, prosecution, disposition, and analysis of minor infractions to the most serious crimes. In the 2018 data reporting issue with the Connecticut State Police demonstrated the detrimental effect of an issue of law enforcement when public confidence in the accuracy of police databases is challenged. We must be confident that the information in law enforcement records is accurate. As I have stated before, that even one officer would misreport data is unacceptable. This bill reinforces and strengthens the ability to hold anyone who has intentionally, and I want to emphasize, intentionally misreported data accountable. Significantly, the bill criminalizes only intentional conduct, making it unlawful for a police officer to enter false information or data in a law enforcement record when that officer does not believe the information to be true and which statement or entry is intended to mislead. As such, the bill does not criminalize inadvertent errors or unintended mistakes by police officers, whom I care deeply about. The bill appropriately recognizes the vast majority of the police in the state of Connecticut act with integrity in all their actions. But the bill sends a strong message that any intentional misreporting of data by even a select few is a serious transgression. The bill ensures that there are significant consequences for any police officer who intentionally misreports data, both by making that act a felony under the Connecticut criminal laws, but additionally making that conduct a basis for the Police Officer Standards and Training Council to revoke an officer's certification. Accordingly, the Department of Emergency Services and Public Protection believes that the bill provides a strong message of deterrence to anyone who would knowingly misreport data, as well as the severe penalties for those who willfully violate Connecticut law. That being said, the Department of Emergency Services and Public Protections and I, as commissioner, appreciate the concerns of law enforcement officers who feel that they are being unfairly targeted by the bill in light of the numerous regulations and certification procedures already required by Connecticut police officers. I want to be clear. We must support our local and state police and look for ways to make their jobs easier and safer. However, gaps in existing law may not sufficiently address the rare situation when an officer knowingly inputs incorrect data in a computer system, such as the racial profiling data. The proposed bill covers the gap. The Department of Emergency Services and Public Protection thinks that this measure.
Commissioner, and I just want to correct myself. I'm used to calling you chief. I called you chief.
Okay.
Commissioner, if you could wrap up, I'm absolutely sure you will get questions. I don't think you have to worry about that.
Respectfully, I'll wrap up here, and I just want to say that we support this raised bill 5055. Thank you.
Thank you. Comment or questions from members of the committee? Comment or question? Senator Kissel first.
Yeah, I'm sorry. This is probably not what the whole focus is. I know that you're here on the governor's proposal, and I appreciate that. But since I have you in front of us, do you have a position on the secondary stop bill that's here today as well?
So I have been in contact with some local police chiefs, and I do not have a position. I want to make certain that our police officers are first and foremost following the law, that they're safe, and also, you know, there's going to be others that are going to be testifying to that today. But I did not come here today to provide a position on that.
So when you said other people are going to testify, is that other people like the police chiefs and groups like that? I'm just wondering if the governor's office or if the administration has a position. Because, and I saw your public press conference where you said there's going to be more enforcement on the highways and we want to get our arms around traffic violations. So this secondary stop bill will have an impact to some extent on our state police traffic enforcement. And so it's your position that I'm confused. Are you just not here on that bill, or does your department not have a position on that bill?
We do not have a position on that.
Okay, thank you, Commissioner. I appreciate that.
Thank you.
Thank you, Senator Kitchell. Comment or question from members of the committee, Representative Sastre.
Thank you, Chairman Winfield. Commissioner, good to see you. Is
Good to see you.
this your first opportunity to be before us as the
Yes,
Judiciary
it is.
Committee? All right, well, welcome. Hopefully it won't be the last. A couple quick questions for you on 5055. So in section 1, this is the section that creates the felony offense for making an intentionally false statement on a law enforcement record. One of the suggestions that's come to the committee on this bill is that this actually should be broader, that it should apply not just to sworn police officers, but frankly to any member of law enforcement, be that a dispatcher, clerk, you know, a non-sworn personnel who makes a false statement on a law enforcement record, that they should be treated similarly, and that it would be a felony offense for, say, a records clerk or a dispatcher to, again, intentionally falsify a law enforcement record. Would that be acceptable to you if this committee were to broaden the language to include non-sworn personnel as well?
I had not contemplated that question. Police officers are held to a higher standard. You know, we conferred with the Chief State's Attorney's office on this, and this was really responsive to what we found with the data entry, issues with the Connecticut State Police. I have not contemplated considering making that bill much broader to include dispatchers.
Yeah, if you could give that some thought and maybe get back to us before
Okay.
our deadline, because I mean, I guess at first blush, it does seem to me that if we are going to hold police officers to this standard, and certainly I believe we shouldn't be allowing police officers to intentionally falsify records. I guess anyone who thinks that's okay, I'm not sure what the justification for intentionally falsifying a police record would be, but if we're going to hold police officers to that standard, it would seem we should likewise hold other professionals in law enforcement to a similar standard. But we'll await your feedback on that. And then turning to section 2 of the bill, this is the part about decertification. Now, the language being added in here is a grounds for decertification would be making a false statement in a law enforcement record. So we'd be making that an express ground for decertification. But wouldn't it be the case that currently, under current law, if someone were found, whether it be a state police officer or local police officer, were found to have intentionally falsified law enforcement records, they could be decertified under the undermines public confidence provision of our current decertification statute, correct?
Correct.
Okay. So as I read section 2, it's really not an expansion of the law. It's sort of a clarification or codification that falsifying law enforcement records would be a ground for decertification, but frankly, it probably currently is and likely has been, at least since the Police Accountability Act passed in 2020 when we added in the undermines public confidence law, correct?
That is correct. This, the way it's written, it closes the gap. It closes the gap so that there's absolutely no question. It's very specific.
Correct. I just want that clear though for legislative intent as we do this, because if there are officers out there who are found to have intentionally falsified records, certainly since the enactment of the Police Accountability Bill in 2020, they should be brought before post for decertification under the existing law and existing languages. Do you agree with that?
I do.
Thank you, Commissioner.
Thank you.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? Seeing that, I want to thank you for joining us, Commissioner. Sorry about the Chief Commissioner thing.
That's okay.
And I also want to thank you for being very clear in what your position is. It is important that folks in your position have a clear position on this for the public to understand. Thank you for joining us. Enjoy the rest of your day.
Thank you.
Next, we will hear from Representative Tracy Mara. Representative Mara here? Okay. Next, we'll hear from Judge Beverly Strike Kafalis. Good morning, Judge. Good to see you again. When you sit down, turn your microphone on and you can have your 3 minutes.
Good morning, Senator Winfield, Representative Stastrom, Senator Kissel, and members of the Judiciary Committee. I am Beverly Strike Kafalis, the Probate Court Administrator. Thank you for the opportunity to testify this morning in support of Senate Bill 324, an act concerning probate court operations and administration. I have submitted written testimony, but just to point out, the chief points of the proposal is to offer corrections to technical omissions in the remote notarization bill that was passed last session, to which the Connecticut Bar Association has expressed no objection, specifically with regard to excluding remote notarization of mutual distribution agreements in a testate estate. It also offers efficiencies in allowing the VA hospital, the federal VA hospital in its outpatient facilities, to be billed the probate court filing fee similar to the procedure for state agencies when it files petitions in the probate courts. We offer clarifying notice provisions to the Connecticut Indian Child Welfare Act to distinguish the different notice procedures between the probate court and the Superior Court, to which the judicial branch has vetted and approved the language. We also add an additional assurance of legal notice to a non-petitioning spouse who is involved in a petition for conservatorship whose whereabouts are unknown, to ensure that notice is effectuated to that non-petitioning spouse and other family members. And we propose amended language to petitions to terminate parental rights so that the statute regarding the provisions and procedures for the petition parallel and are consistent with the language on its companion statute regarding the hearing procedures. That terminology is important to ensure there's no conflict between statutes and use of different terminology, and also is consistent with other parentage statutes. Finally, we do request restoration of the filing fee for petitions for name changes. General public policy, frankly, nationally, is that petitions in courts, whether federal, local, state, or otherwise, require a court filing fee. And certainly in all such instances in Connecticut, access to the probate courts and other courts is assured for anyone who is indigent and unable to pay by being able to seek a waiver of that filing fee. In fact, probate courts granted nearly 16,000 fee waivers in fiscal year 23, and we will certainly continue to do that to assure access to the courts. And I'm happy to answer any questions you may have.
Thank you. Comment or question from members of the committee? Comment or question? Give me a second to get my screen back up. I don't see anyone. It is good to see you, and I'm sure I will see you again, whether here or appropriations or somewhere. Thank you very much for joining us this morning.
Thank you all.
Next, we will hear from Rafael Rosario. I'm told that Representative Mara is in the room. You may come forward. Oh, there you are. Good morning. Good to see you.
Committees this morning.
We understand.
Thank you so much. Thank you to the Judiciary Committee for having this public hearing this morning. My name is Tracy Mara, State Representative of Darien and Norwalk. And I'm coming to you today to speak on in opposition of House Bill 5297, an act concerning the decriminalization of possession of small amounts of psilocybin. And looking at some of the testimonies already in favor of decriminalizing psilocybin, a common thread emerges. Individuals are advocating for its decriminalization to permit self-medication. However, this legislature has previously ventured into legalizing federally illegal substances, such as cannabis, which is a trend that really should not continue. The state of Connecticut really lacks the resources to assess and regulate psilocybin effectively. This is a role better suited for the FDA, which is already engaged in this task. Psilocybin is under rigorous investigation and is in phase 3 trials right now, treating major depressive episodes and treatment-resistant anxiety and depression. And it must be noted that these treatments are being studied with psychotherapist-guided experiences through the hallucinogenic effects. Self-dosing raises concerns, particularly within an unregulated market. Decriminalization without a legal framework for production in cells will undeniably result in illicit manufacturing. While psilocybin itself may not be directly associated with overdoses, the unknown additives, contaminants within an unregulated market may raise substantial safety effects similar to our opioid crisis. It is imperative that we let research and development and pharmaceutical companies continue to do their comprehensive due diligence on psilocybin, and that thorough, time-intensive FDA approval process ensures safety and effectiveness of medications for consumer use. And we should really not hastily repeat the steps taken with cannabis. It is critical that these substances should not be self-administered without professional guidance. So by letting the regulatory process take its course, we can ensure that it would be deemed safe and efficacious. And psilocybin really could offer some very promising outcomes for and under controlled measures. But premature decriminalization may inadvertently convey to our citizens and the residents of Connecticut that it is safe for casual use, which is misleading based on current knowledge. Furthermore, this may result in an ineffective application on illegal sources and sidelining regulatory pathways for psilocybin.
Thank you.
I ask that you oppose this bill. Thank you so much.
Thank you. Comment or question from members of the committee. Senator Kissel.
Thank you very much, Chairman Winfield. You can thank Representative Gilchrist for spotting you in the audience.
Thank you. Appreciate that.
It's there. I share your concerns. One of the other committees that I'm lucky enough to serve on is general law. And that committee has cognizance over consumer protection, which in turn has cognizance over the legalization of marijuana, the creation of rules and regulations regarding our dispensaries. And I have to say, just in the passage of the last couple of years since we legalized recreational marijuana, there's just been a Wild West booming industry regarding ways that they can sell THC. And, we sort of understood at the outset just a few years ago that, you can smoke marijuana. There were some, brownies, foods, edibles. But I got to be honest, now we're getting our arms around THC and seltzer water. And it's very hard for the Department of Consumer Protection to actually measure quantities so that we can put in bright line tests as far as what products can or cannot have. But it's impossible to enforce because we don't have the instrumentalities to measure it. We have other groups like package stores that say, oh, seltzers, it's a fluid, just like a beer or wine, and it affects one's psyche. So we want to be able to sell it. And then you have Chairman D'Agostino and Chairman Roney saying, well, we thought the dispensaries were where that had to go. My question is regarding psilocybin. I understand that to be mushrooms, but I don't know where we are in 2024 regarding mushrooms. Is there like an industry out there regarding that product? as far as how it's ingested. And if we go down this path, can we, in the blink of an eye, like with legalized marijuana, find that, you know, the good old American free marketplace is like rushing to fill that void with a variety of ways our constituents can ingest or smoke. I don't even know if you can smoke psilocybin, but I'm just wondering, where are we as a state regarding that sort of new field?
Yeah, thank you, Senator Kissel. I think you make some very good points. I would like to point out one of the differences with psilocybin versus cannabis is that the process for regulating cannabis really wasn't there. So while I do disagree with the route we took with cannabis, I understand the reason behind it a lot more than I do with psilocybin. We are in phase 3 trials with psilocybin. People that are going to come before you today are saying this is effective because they have been working with doctors on getting a very specific dose, whether it be a 5 milligram dose, a 25 milligram dose. This is, they are led through this with a therapist. This can be very effective. But instead of us, we have put things into place that will get us to that regulation, that will get us to that safe use. And all of a sudden, we're changing the rules for everyone. And I think that's where we are unfair. We could have a very effective drug available for major depressive episode or treatment-resistant depression. And I think that is a really good thing. And we are so very close. I hope that you get a chance to take a look at my testimony. And just at the bottom, just a little bit of a nerdy bit, I just put in the NDA process, just so you see how lengthy that process is and understand how far we are when you're talking about phase 3 trials. So I just ask that we really give our companies that are taking the proper route, we give them a chance to really show that this is effective instead of then making magic mushrooms that have psilocybin in it. You don't know what the dose is. You're gonna guess on the dose. You're gonna have manufacturers popping up, and it's gonna be a black market on this. And I just think that that's not what we want. We want to have effective treatments for this, and we're very, very close to that.
Well, I really appreciate you taking the time on this issue. I don't recall a lot of testimony when a similar proposal came before us last year. And we do have a huge pharmaceutical industry in the state of Connecticut, in many respects, very cutting edge. Many years ago, I took a lead in creating the medical marijuana program we have in Connecticut. And in many respects, it was very helpful, especially in the treatment of epilepsy. But it has to be highly regulated, and the dosages are really fine-tuned. And if this has an implication with mental health aspects, anxiety, depression, things like that, all those medications are fine-tuned. In my years here in the legislature, when I've served on public health, whenever there was notions of transferring medicines that are used for mental health to generic, there was always a huge pushback from advocates because the generic wasn't as fine-tuned, and it just has a different impact. So I agree with you that if there's going to be medical implications for treatment of individuals, that we should allow the research to continue. My last quick question is, do you have a sort of a time frame for if we as a legislature want to put pause on this to allow the research to continue, so that when we eventually do move forward, I would suspect with at least its utilization for some form of medication and treatment, how long we have to wait? Is this about a year we have to wait, or how long do you think?
So looking at the clinical studies that are out there now, it looks like the phase 3, some of the phase 3 studies are going to be ending next year. So it does take it takes about a year process for the FDA to then look at all those before approval. So we could be a couple years out, but the thing is there are trials. So people that are wanting to, that need to get therapy, there's going to be opportunities for them to get into trials along the way. But that's one company. And I know for a fact that there are other companies that are entering that space too. So it's not just, you know, this is something that we are seeing effectiveness with. Now, looking on the flip side, there are side effects. So people that are taking it that don't have treatment resistant issues or major depressive episodes, it can trigger psychosis. So this is also a reason why it's really appropriate to have this, you know, a psychotherapist there guiding you along the way that's focusing on this as being a treatment and not just a hallucinogen.
Representative, I really appreciate your testimony. You've done a lot of research on this. I like the whole wonkiness kind of approach. I love that kind of stuff. One last quick follow-up. If someone in our watching on CTN or in the audience wants to participate in these trials and they feel that there's a need, how would they try to get that information? Is it on the web somewhere, or should we urge them to contact your office and you can direct them? And I don't want to give a shout out to these corporations that are doing this necessarily, but you said there's at least one major company pursuing this. And my guess is if there's money to be had, you know, Big Pharma is going to get involved with both feet. So
yeah, sure. I mean, if any, you know, you can certainly see the companies that are doing the clinical trials. If you check out my testimony, you can, there's a link there. You can look at the companies that are doing the clinical trials, or you can talk to your doctor and see if they can lead you to someone that's doing a study.
okay, great. Thank you so much. Thank you, Chairman Winfield.
Thank you, Senator Kissel. Representative Mara, did you follow the work of the task force?
Sorry?
The task force that did the work around this issue, did you follow their
No,
work?
I have not. No.
And you said a year or so, maybe a couple of years, you are aware that we're decriminalizing a small amount, correct?
Yes, I'm aware that you're decriminalizing a small amount. I'm also aware that where supply is needed, demand comes. So decriminalizing a small amount is going to put pressure on the market to then make it. And that's where my concern is those unintended consequences. And also decriminalizing that small amount does send a message to people that we think it's okay, which I don't think it's okay. I don't think that this drug, I think that this drug really does have good potential. And jumping the gun on the FDA, I think, is probably not the way to go with this. I do understand the issues around it. You know, no one wants someone to go to jail with, you know, a small amount. I understand that.
But how do you get there without decriminalizing the small amount?
Well, I guess, you know, I did try to look and see how many people were arrested and went to jail for a small amount, and I couldn't find it, but I could be wrong.
My question to you, as the person advocating for us to not do this, is if you think that this, and I'm assuming, I don't want to put words in your mouth, so correct me if I'm wrong. If you assume that this is, I haven't said anything, so hold on a second. If you assume that this is a public health issue, as we've come to talk about the issues of drugs, we seem to get it with fentanyl, but not other drugs. But as we come to think about it with drugs over the years that I've been here, and you don't want the potential for someone to face criminal penalty for small amounts, how do you get there without the decriminalization of a small amount?
I do not think you should change this. I do, you know, my hope is that people don't have small amounts. That's the signal I want to send. You shouldn't have small amounts. You should go through a proper trial. So that is the message I want to send to people.
Comment or question from other members of the committee. Senator Kissel.
Thank you very much, Chairman Winfield, for the second time. It's my understanding that the task force recommended that DEMIS would actually move forward with a pilot program regarding this activity, and that we have not, as a legislature, funded DEMIS to do that, so that aspect of the task force recommendations has not actually taken place. And it's this legislature's position that that should actually take place prior to us moving forward full force on this legislation. So I would suggest, in response to Chairman Winfield, that you go back, review all the recommendations of the task force with that in mind, so that if this does get voted out of this committee, you can address those issues on the floor of the House if you have concerns.
Thank you,
Mr.
Senator
Chair.
Kissel. I appreciate that.
Thank you, Senator Kissel. Comment or question from members of the committee. Representative Odette.
Thank you, Mr. Chair, and thank you for your testimony. Sorry, I missed part of it, running back and forth with meetings, but look, I agree with you. I've got concerns here, people operating. Look at what's happening with the marijuana. I mean, the way that statute was enacted prevents officers from investigative stops when they see it. And I think with all the road problems we have right now, and I appreciate your testimony here and bringing it to our attention. This is just going to lead to more problems for us, I think. So it's going to make it more normal for
Yes,
people to do it.
thank you.
Thank you.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining.
Thank you
us.
so much. Appreciate it.
Rafael Rosario. Charmin Leon.
Good morning, and thank you for having me. My name is Charmin Leon, and I served with the Cleveland Division of Police in Ohio for nearly 13 years. Currently, I am with the Center for Policing Equity. We are a research and action organization made up of former law enforcement, academics, and community engagement specialists that use scientific research to identify and reduce racial disparities in policing. HB 5324 represents an important step towards addressing equity and preserving officer resources and morale. In the time that I spent on patrol and leading the background investigation and recruitment units, I found that the officers focusing on non-safety stops did not equate to those most effective at discovering serious crimes. It is also demoralizing for the officers who must pick up the additional calls for service while their coworkers are tied up executing those types of stops. Officers who work to engage in more effective crime-fighting strategies do not spend time generating citations in the name of being productive, because it is a false narrative and undermines morale. It places a greater burden on a smaller number of officers. To improve recruitment and retention, we should be prioritizing practices that actually solve crimes and improve public safety. This is why people want to be the police. There is a retention problem in law enforcement, and ensuring our officers can demonstrate effectiveness in the practices we employ increases the ways officers find meaning in this work. Enforcement of non-safety related stops is an ineffective, inefficient, needle in a haystack approach to addressing crime and road safety. Peace officers play a crucial role in ensuring community safety. Enforcing these minor infractions diverts our attention and resources away from more urgent matters and is not in line with intelligence-led policing, which is the trajectory, the evolution of our profession. Additionally, enforcement of these minor infractions leads to the extraction of resources in our most vulnerable communities. And more than anything else, it criminalizes poverty. That's why we're seeing laws like HB 5324 passed across the country, including in Virginia, Oregon, Philadelphia, Pittsburgh, and Memphis, and related policy changes in the San Francisco and Los Angeles police departments. Every study of states and jurisdictions that have reformed non-safety related stops have not found any negative impact on public safety. HB 5324 is a win for law enforcement, racial justice, and public safety in Connecticut, and we urge you to vote favorably. Thank you.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? If not, thank you very much for joining us today to share your position. Have a great day. Next, we'll hear from Victor Costanza. Good morning. Welcome back to the committee. Sit down, turn your microphone on, and you have your 3 minutes.
Hello, everyone. Thank you, members of the Judiciary Committee. My name is Victor Costanza. I'm the lead organizer and founder of Connecticut for Accessible Psychedelic Medicine. I want to bring out that the representative who spoke against it, her points, there was a lot of ignorant comments on how psilocybin is used and how it works. But I want to share my story with psilocybin. I've suffered with PTSD, alcohol use disorder, and borderline personality disorder. It's destroyed my life. I've I've been in there was a moment in my life where I had nothing, absolutely nothing because of the mental health disorders. Once I got into recovery after a really bad DUI accident, um, uh, it was hard. It was hard to move on. It was hard to move on from the public shame, the leaving the organizations that I was a part of. But I was at the point of relapse again this past July, and I was brought up with the idea of psilocybin. And I tried everything, by the way. I've done intensive outpatient programs. I've done Vivitrol, which is a very common medicine used to get rid of alcohol cravings. But I was at my wit's end. Nothing was working. So I tried psilocybin and I did my research. And I came out with instant relief that same day. It's an intense trip, yes, but it was instant relief. And I still have near zero depressional symptoms. I haven't had any cravings for alcohol. My life is totally has a much better outlook than it has before. But that's the story you're going to hear a bunch of times through written testimony, through the research, through testimonies from across the country. This last January, we had a psychedelic forum where all the representatives and senators were invited to, which had the national experts. And they all said the same thing, where it is safe to use for personal use. And mind you, this is not a new thing. Psilocybin is not new. It's been here for thousands of years. That's enough citation. It's been, there's research from the 60s, the 50s. It used to be a giant therapeutic tool in that time. It was only banned because of the Controlled Substance Act in the 70s, where all drugs were dangerous, you know. But this bill is lacking a lot. It's not strong enough compared to the ones in Colorado is the ideal decriminalization / legalization bill. The bill should include home grow, which actually answers the question about where are you getting your psilocybin. It should include sharing gifting. Psilocybin is not cannabis, as psilocybin culturally is an indigenous medicine, and it's very communal. And the last recommendation is that the bill shouldn't have fines that really hurt folks or stipulations that would hurt folks from getting social services. Okay. Just amend the bill. That's my last thing.
Comment or question from members of the committee? Rep. Howard first.
Sorry, thank you, Mr. Chairman. I just have one question, sir. Thank you, and
Yes.
congratulations on your success. As a user of this, and if you're not comfortable saying this, and you can tell me that's
No, it's
okay,
fine.
but do you feel that impairs your motor skills, specifically your ability to drive?
Oh, 100%. One of the main things about this is that there has to be a lot of education behind it. People don't, if you went out of the street and asked someone about it, people would have like, oh, you would trip, you know, that's not, you do trip, but there's way more into that. So no, you should not be using this when you're going to go to drive, but in several reports, they're not seeing that people are using while driving. Like once you take psilocybin, it takes 15 minutes for it to kick in for your digestive system. You're going to be out. You're going to flatten yourself. So,
And how long are your motor skills, we use the word deficient or affected by it?
so
In
it
your best
really,
guess.
so it depends on how much you're using.
Mhm.
The most popular way to use it right now is microdosing, where you don't trip. You just get like the antidepressive effects of it. Now that you can drive with, you're fine. You're not high per se. Like if you were to smoke a joint, you feel something. It's like, no, you really feel good. But let's say you were to take a macro dose, which is about anything above 2.5 grams. Yeah, that's where, you know, you shouldn't be driving. You should be home.
Okay, thank you so much. Thank you, Mr. Chairman.
Thank you, Representative. Representative O'Dette.
Thank you very much for your testimony. Did a doctor prescribe the psilocybin?
No, it's not allowed.
So I'm wondering, so whenever we see that people are taking this for medicinal purposes, that's self-medicating. Is that fair to say?
Yeah.
Would you be amenable to, you said there's, and I will fully admit, I have no idea about this substance.
Yeah, right, yeah.
If you want to say that I'm talking out of ignorance, it's 100%
Mm-hmm.
true. But we're being asked to vote on this, or at some point in time, may be asked to vote on it.
Right.
So that's why I'm asking these questions. So there's a way you can grow it so that it doesn't have the psychotropic effects. Is that correct?
You're asking if there's a way to grow it without.
The psychedelic effects, or
No, if you're getting, so the DEA recently said that the spores are legal to have. You can have the spores because there's no psilocybin in them. If you were to grow the spore into psilocybin, you get the correct spores, and that's how you get your psilocybin. It's not like you're growing portobello mushrooms or something.
right,
Yeah.
right. So, but you were talking about how the microdose does not have the psychotropic effect.
Oh, okay. Yes. So the most popular way that people are using it is microdosing. Now, microdosing is 0.5 grams. It's a very, very small amount. Now, the representative who spoke before about this said that it is dangerous for folks who don't have mental health disorders. That is not true. Microdosing has been proven to increase creativity, increase performance, lessen anxiety, and then overall have just a better mood in general. I like to give an example, like it's what an antidepressant should be doing, but it's very natural it's okay for folks, anyone, to take it.
Well, and I hear you, and I'm not dismissing you, but
Yeah.
As I understand, you're not a doctor.
No.
So I'm wondering, do you know of any doctors that may be testifying to that effect?
Oh yeah, there's a bunch of doctors who will say the same thing on how that works. We've had the psychedelic forum that happened in January. We had doctors from Harvard and Yale talk about psilocybin. I do recommend folks. It's about almost 4 hours of information of just professionals, both on the policy and the medical side, talking about this.
Do you have written testimony by chance?
Yes.
Is that link to that forum on the?
I think I could resubmit it with the link.
If you could, that'd be great, because
Yeah.
I will take a look at it. Thank
Okay,
you.
yeah, no problem.
Thank you, Mr. Chair.
Thank you, Representative. Representative Fishbaum.
Thank you, Mr. Chairman. Good morning, sir. You said that it would not be good to use while driving, but what about while at work?
If you're using 0.5 milligrams, you should be fine.
Okay, but what is to restrict the 0.5? Since what is to restrict one to 0.5 milligrams?
What do you mean? Like how would one measure it?
Yeah, I mean,
Yeah,
well, I mean, obviously there's physical measuring, but the law that's before us does not limit to 0.5 milligrams.
No, so it honestly the amount in the bill should actually be increased to 1 ounce. The reason being is because the way you microdose is actually in a cycle, and 1 ounce should be enough for 1 month over a cycle. There's a bunch of methods people typically would do 0.5 milligrams per 3 days, take 1 day break, do 3 days again, but there's a bunch of methods to do so. But that's why the possession is, because logistically it would be annoying just to go out for 0.5 milligrams every single day. So it's rather to have someone have a small amount so people can actually divide it throughout the month.
Okay, and I'm trying to put that together with what you said about driving. So you said you should not be ingesting this substance while you're driving.
Over when you're taking a big dose, yes.
Okay.
Mhm.
So limiting it to a microdose. So I would assume that you shouldn't be, if you drive a forklift at work, it would be the same sort of situation.
If you were to microdose, you'd be able to do your job.
Okay. And what about while drinking alcohol?
Alcohol is way more dangerous than psilocybin, but I don't think there's any kind of like a mixture of substances that would mess you up. Like, for example, psilocybin shouldn't be taken with a MAOI, which is a certain kind of antidepressant. It will fatally kill you, but it's a very uncommon prescription of medicine that doctors prescribe. Psilocybin with alcohol wouldn't have that effect, but I don't think there's information on that anywhere just
So
yet.
if this law, as it presently exists, were to pass, it would permit the prescription of this substance?
It would permit the self-use of having this medicine at home. And the reason being is because at some point you're going to come back to this conversation once the FDA approves psilocybin. They're about to approve MDMA, which is Molly and ecstasy, for medical use. Now, what we're seeing already is that in Massachusetts, no, sorry, not Massachusetts, in Oregon, the first state to legalize it fully for medical and personal use, is that the treatments themselves range from $6,000 to $13,000. No one person in a working family can afford that. That's why the decriminalization is an important piece, because one, of how long people have been using it, and two, it's really expensive to do those treatments. Insurance won't cover it just yet until there's like a national FDA approval of it. Companies are charging it up to the wazoo, so it's important for folks to have the ability to do it at home or in the sanctity of community, because
Right,
that's
so the question had to do with essentially how one would acquire this product should we were to legalize the possession. They would
So,
not,
oh,
they would
okay,
not be
yeah.
able to get a
Mhm.
prescription in connection.
No, you cannot.
Okay.
Mhm. Nor can
So-
you get into a clinical trial. You can't.
So we would, if we were to pass this law, we would be saying to individuals, you have to acquire this substance through an illegal means.
Yes, because that's the only way. But the thing is, the difference, and I can say this, the cannabis culture and psilocybin culture are significantly different. Where psilocybin, you really, really have to trust where you're getting it from. And in the psychedelic circles, like it's a lot of word of mouth and a lot of approval. It's very I can say it sounds hippy dippy, and one of my colleagues say that psilocybin, the culture of it sounds like a bunch of hippie nonsense, but it's not. So it's a lot of communal action. When folks want something, someone say, "Oh, here," or like the sharing gifting part, where I'm telling you that it should be a part of it. That's where you can create an alliance of folks who you can start building some sort of network of saying, "Oh, sharing gifting is allowed. Okay, my friend is growing it. Oh, I trust them. Here you go."
But ultimately, at the end of the day, if we were to approve this, we would be saying to our residents, you have to deal with the criminal element to exercise this right, so to speak, that we're giving you.
But it would be decriminalized if it were that at that
Well,
point.
that would be a different situation,
Right.
okay? Because it's an illegal substance under at least federal law. You know, when I got sworn in here originally in 2016, I took an oath to the
Right.
Constitution, our state and federal constitution. And under the federal constitution, the supremacy clause says that federal law trumps state law. When they are in conflict, the federal law takes over, right? So how am I, without violating my oath, possibly supporting this if it's in violation of federal law?
I mean, it happened with cannabis already.
Oh, I know.
Yeah, but like that logic, you can apply it back because legalization happened just a few years ago, full legalization with the market and stuff like that. But it started with the decrim bill.
And then
At that point, it was the same method. Like
the argument was, well, they're doing it anyway.
Yeah.
So just legalize it. Well, I mean, if you take that to an nth, there's illegal guns in the cities too.
Right.
Just legalize them. I don't agree with that.
But I'm
But
not comparing guns to psilocybin either.
Well, but it's the fundamental philosophy of federal law over state law. So
But you're already doing that with cannabis, is what I'm saying.
I didn't do it. So
Yeah, but the state has already done that, along with 30 plus other states have said no, like we're legalizing cannabis. There's potential that cannabis may be descheduled this year, hopefully, but ultimately it has already happened. The state has already done something where it has gotten like on top of the federal government. It's like, no, we're doing this.
And I know I'm getting flagged a little bit here, but if you look me up before I got elected here, I wrote an editorial
Okay.
about how cannabis should be legal. And then I looked at my oath, and the Constitution provides. And what I said was that if the feds made it legal, I would perhaps have a different opinion on it. But that's what I'm wrestling with, right? Is I took an oath. It's illegal under federal law. How can I cajole my constituents into, engaging in an area that the feds tomorrow could say, we're going to go into every state and we are going to enforce the federal law. And now I've essentially, as an elected representative, entrapped my constituents into violating the law. So that's what I'm wrestling with. But thank you. Thank you, Mr. Chairman.
Thank you, Representative. Comment or question from members of the committee? Senator Marr.
Thank you so much. And thank you, Chairman. And I would like to congratulate you on your recovery from alcoholism. And I did hear not all of your testimony, but most of it. My question to you is, how many hospitalizations, in facility outpatient treatments did you go through for alcoholism?
I've been through 5 IOP programs in my lifetime, in different parts of my life. I'm turning 28 next month, so I've been trying to deal with this issue since I was 19.
19. So, and how long ago did you start using psilocybin?
This past July.
This past July. And can you tell me what the difference was for you, speaking about your experiences trying to not drink and stay on the program versus once you started? Can you compare and contrast those two experiences?
100%. I'm also studying to be an addiction counselor as well. I'm a Gateway student. So along with me learning about it and being a part of it, it is significantly different. When you go to IOP, you're in a program for about 1 month of intensive group programs. You constantly check for urines. There's constant group work. But the thing is, in my experiences, and if you were to ask others in recovery about these experiences, it feels flat. People probably can't connect to it. People feel alone in the recovery. I don't like using this term, but a lot of people who stop with alcohol can be considered dry drunks, where they may not be drinking, but they're still not having a good time with their life, or they're very angry, or I was that person. I was the dry drunk. With psilocybin, a very common analogy is like it's 10 years of therapy in 5 hours. I came out feeling like a different person, like I'm ready to take on the world, like I'm not afraid of anything. And it in the first time in my life brought me clarity and brought me self-forgiveness, because the trip, if you talk to folks, all trips are different. Mine was very, very intense, but I was on a couch the whole time. But when it ends, it's just like certain, like, wow, everything's going to be all right. And no one can say that coming out of an IOP program or taking Vivitrol, because you just see life as doom and gloom. But for some reason, psilocybin does the opposite. It helps you, but it also helps you become a better person. It changes your mind, essentially. And there are some science behind that with neuroplasticity, that it changes thought pattern, it changes habits, or it gives you a sense of making better choices for yourself.
So you just referenced neuroplasticity. And also I was wondering, when you did this 5-hour experience, was this a guided experience, or were you doing it on your own?
So the very common way is that you have a trip sitter. So that's the difference between cannabis and psilocybin, is that you need a trip sitter. You need someone who's completely sober to be there. You don't need a therapist when you're doing this. You just need someone who is sober and who is willing to say, hey, everything's all right. Or, you know, to provide water. If they're freaking out, to help them, guide them through it. But it's not therapy, like a therapist. A trip sitter is not a therapist, but a trip sitter is essential for the trip itself. So yeah, I didn't have a guided person, but I had a trip sitter.
And so what you were talking about before was white knuckling it after coming out of IOPs,
Yeah.
trying to fit into the general population, but not feeling part of things. How is it different after the psilocybin?
So just before you answer that, I'm just going to say this. I'm trying to give everybody a little bit of leeway to get their questions to put some color to this. But let's all try to stick to the bill itself and not an individual experience.
Noted. Thank you.
Anything else?
You can answer that question. I'm just trying to keep us from going too far outside of what.
Oh, no. Oh, I'm sorry. What was your question again? Because I got.
I think that we'll leave it for
Okay,
your
that's fine.
previous
Yeah.
testimony. Thank you so much, Chairman.
Thank you, Senator. Comment or question from other members of the committee? Representative Quinn.
Thank you, Mr. Chair, and thank you for being here and sharing your story. You testified earlier about only acquiring this from someone that you know and trust. What dangers are there if you don't get it from someone that you know and trust?
Being scammed for money, getting a mushroom that doesn't have any potency, not knowing the strain. I know people try to bring in the whole, which is a real issue, the fentanyl crisis in here in this country, but there hasn't, to my knowledge and to what I've read, there has not been an issue with fentanyl with psilocybin. So that's really the issue. Or, some people tend to ship it internationally, which is a thing. Or they get it from places where it's truly legalized, like Oregon or Colorado, where you may have some trust there, but those are essentially the risks. And also not knowing the strains and how potent the mushroom that they're giving you is, which, there's some mushrooms that, maybe taking 2 grams of it and one strain may not feel enough, but let's say you take 1 gram of really something potent, then it'd be a really, really strong trip and it would be kind of uncomfortable for the person. So that's really what you're risking.
And in Oregon and Colorado, is it completely legal? Or is it similar to what we're trying to do, which is just decriminalizing the small amounts?
So in Oregon, it's a full it's a full market. They have their own they created their own department just for psilocybin and other psychedelics, both to regulate the mental health side and the market side. Colorado, even though the law has passed, it's still being implemented. They're still working on it to finally for it to function fully. But it also allows a market. Massachusetts, I believe, is creating, because Massachusetts is having a ballot measure later this year, and maybe right or wrong in this, but I believe it creates a whole new department for the state to both regulate the mental health side and the market side. So in other states, it's severely different than just doing the small amount of possession here in Connecticut.
Okay, and then last question. Do we have a lot of people getting arrested for possession of this in Connecticut?
We can't find the data on that.
Within your communities, do you know of people who say, hey,
No.
I keep getting picked up for this?
No.
Okay. All right. Thank you.
Thank you.
Thank you, Representative. Representative O'Dea.
The second time and last time, just one.
You're good.
This is good. This is going to sound like an old man that I guess I am. Why would you need a sober trip advisor to be with you? Like, what happens?
Because when you're in a trip, you do hallucinate. There's a lot of auditory and visual stuff going on. You may in a trip, you may a lot of stuff can happen where you may feel something and it's like, oh, I'm freaking out. And the sober person's like, no, dude, there's nothing's happening. You're okay. Sometimes the trip can lead you to a very traumatic memory. It could bring you back into your memories and really, it could be really, really strong on how you felt in a traumatic memory. And the trip sitter there who is sober, and you're saying, you know, I don't know what's going on and stuff. Essentially the trip sitter is to make sure that there's a touch of reality to that. That's the whole importance of it. And that's how psilocybin has always been used, you know, in the hippie era, till now. So
Representative O'Day, I'll just remind you, as I reminded Senator Marr, we're not talking about the experience so much as what the bill does.
No, I know, I hear you. It's a decriminalization of a minor amount, but the micro amount doesn't allow you to trip. Is that
No.
correct? So other than tripping, so the medical benefits you get are from the micro, you can get from the micro amount, correct? The non-tripping?
Yeah, but non-tripping, you still get benefit from it. Like, you know, elevated mood, like if you're feeling, it does battle depression in a small amount, but even in the clinical trials, to get the full therapeutic effect, you're taking a macrodose.
It just, anybody, if you need a trip sitter, it sounds like a bad trip idea to me, but I'll leave it at that. I appreciate your testimony here today and educating me, and I promise if you send that to me, I will review it.
Yeah, definitely.
Thank you, Mr. Chair.
Yeah.
Thank you. And I will remind members of the committee that we are all free to engage with folks who are not sitting in front of us on aspects of any of this stuff that may go beyond the bill, but that we find important to know. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much, Mr. Costanza, for joining us today.
Thank you.
Chief Carl Jacobson.
Good morning, Chairs Winfield and Stratham, Vice Chairs Flexer and Quinn, Ranking Members Kissel and Fishburne, and distinguished members of the Judiciary Committee. Connecticut Police Chiefs Associations represents the interests of all police chiefs in the state. Collectively, the members of the association oversee the operation of over 7,000 law enforcement personnel. CPCA would like to offer a position on the following bill, HB 5324, an act establishing secondary traffic violations. We do believe that some of the bill is in the right direction, but we do have some issues with some of the bill, and we feel that it needs to be further discussion. For example, a car without properly functioning headlights or taillights poses a hazard to both the driver and other motorists, especially at night. Non-functioning headlights or taillights may also be indicative of other potential dangers, such as a driver who recently caused damage to their vehicle and lights due to impairment. I remember in my 26-year career working the 3 a.m. shift, the midnight shift, it felt like sometimes every other car that we stopped just to tell them their headlight was out. So if their other headlight went out, they would still, be able to fix it. It happened to be a drunk driver. So it's very imperative that we still have the ability to stop vehicles for this. This proposal also comes at a time when there's a renewed emphasis on traffic safety due to dramatic increase in serious accident-related injuries and fatalities on Connecticut roadways. It seems counter-initiative to further reduce enforcement of traffic-related offenses at a time where traffic safety is among the most pressing public safety issues. I do feel that in hearing some of the other testimony, that it's not just about lessering interactions with police. We need more positive interactions with police. And I do applaud the legislature for things in the police accountability bill that have had us as chiefs hold our officers more responsible. My department alone has fired 9 people in the last 2 years, 1 for a bad traffic stop interaction. But I wanted to look at some data, and over the last 5 years, we've stopped approximately 46,000 cars. We don't have any obviously line of due to shootings or anything like that. So I reflected on internal affairs complaints, and I found that over the last 5 years, related to traffic stops, there were only 22 internal affairs complaints. Now, is that a great depiction? No, but it's a very small number. So 0.004% of our traffic stops were a bad interaction in a 5-year period. I believe as chiefs, we need to hold our officers more accountable. They need to treat the community better, and we're working on that. We're working towards that. We've been given tools by all of you to do that. But I think at a time when we see traffic fatalities rising, we need the ability to stop vehicles. Oh,
Thank you. How much more did you have to go?
just some quick stats. I'm good, sir.
Okay.
I'll
All
add
right.
them.
First, it's good to see you, Chief. And I believe you have a question from Chairman Staffstrom.
Thanks, Mr. Chairman. Chief, good to see you. Chief, you started at the beginning saying there were parts of this you support. So do I take it the parts of the bill relating to making, for example, window tint a secondary violation? Police Chiefs Association is okay with that?
No. I was referring to things like 2 plates, plate light, some of the minor things, not tint. I've been in a car that's fully tinted above the legal limit, and I've almost crashed several times because you can't see in the dark. So that's one of them that, I'm sorry I added that in. That's not the CPC's direct testimony. That was my direct testimony.
Okay. How does it work with window tint though? Because I've always been curious. How do you know when you're stopping a vehicle whether it's over the legal limit for window tint or not over the legal limit?
So there should be, so on a car where it's not extra tinted, there's an actual tint rating on the window. So especially newer cars, there'll be a tint rating on the window, which most of those you can immediately identify are legal. With extra window tinting, there's little simple things like if you put your hand behind the tint and you can't see your hand, it's illegal, right? But we also do have tint meters within the department.
I get it once the car is stopped, but this is about being able to stop a car for what you suspect is illegal window tint. And so if a car is driving down the road at 45 miles an hour or faster, how do you know as the officer sitting there doing traffic enforcement whether a tint on a car is more than the legal limit or less than the legal limit?
So I haven't been on the road in several years, but I would say back in my experience, if you couldn't see anybody at all inside the car or anything inside the car, it's more than likely illegal. But I wish I had a better answer for you. I know there is. That's why I feel that we need to sit down and talk about this further. It wouldn't be with someone like me. It'd be someone in my traffic unit that performs stops like this, who has better answer.
Yeah, no, I mean, I got to be honest, because like, you know, I don't know the answer, but I mean, this is certainly not saying that having window tint that is illegal is allowed or acceptable. All this is saying is you can't pull someone over for a suspected violation of being too tinted, I suppose, or whatever the proper term is. But I guess what I'm trying to figure out is how, under current law, right? How is this enforceable now? How is it that you have probable cause to pull a car over believing that it has window tint that's too dark? I mean, if the criteria is not being able to see the person in there, I'll tell you right now, there's a whole heck of Bridgeport Police Department cars that would flunk the test. Because as I'm driving around Bridgeport, I see the police cars that are so dark and so tinted. I can't tell whether there's an officer or 2 officers or male, female, whatever inside the car. It's too dark. So what is the criteria? What is the criteria? Let me ask it this way. What is the criteria the New Haven Police Department currently uses for allowing an officer to pull over a car for suspected window tint violation?
So I think that, at nighttime it's different because you're not going to be able to see in the car either. And I don't believe that's, your primary reason for a stop at nighttime, you know? But during the day, if you cannot see any form within the car, you're more than likely have illegal tint. Like you said about the Bridgeport cruisers.
Okay. So, I mean, the New Haven cars, do they have, are there cars in the New Haven fleet where you can't see inside and see the individuals then?
Yeah, I mean, related to surveillance and different types of units like that, not your basic police cars, no.
Okay. Thank you, Chief.
Thank you. Representative Howard.
Thank you, Mr. Chairman. Chief, in line with the chairman's questioning, were you basically saying that sometimes it's so obviously over the limit that those are the ones that get stopped?
Yes.
So as an example, perhaps you don't know how tall LeBron James is, but if you're looking for somebody who's 5'4", you know it's not LeBron James.
Yes.
Okay. Next question for you. Have you ever seen the DDAX report, the data-driven approach to crime and traffic safety?
No.
No. But you've been a police officer for 26 years.
Yes.
In your experience, if you, as a police chief, flood an area with car stops, regardless of the reason, do you see motor vehicle compliance come more into line then?
Yes. And if I could finish in the end of my statement, I wanted to make one point. In 2022, the department stopped approximately 7,000 cars, and we had 19 traffic fatalities. In 2023, we stopped approximately 12,000 cars, and we only had 11 traffic fatalities. Now, I can't say that's the only reason why we had less traffic fatalities, but I can tell you it helped. So I wouldn't say the word flood, but I would say when you strategically have areas of your city that are having multiple accidents, to be able to stop people and slow the traffic down. And just like I said in my statement, people see cars being stopped and they just naturally slow down.
Thank you, Chief. My final question. Proponents of this bill say that it's more important for officers to focus on things like speeding, distracted driving, and impaired driving, all things that we all know are the major contributors to fatal crashes. So in your time as chief, how many officers have come into your office and told you that they would like to get around to stopping speeders, but they find themselves too busy with things like out tail lights?
Never.
Never. Thank you, Chief. Thank you, Mr. Chairman.
Thank you. Senator Kissel.
Thank you very much, Chairman Winfield. Appreciate your testimony, sir. I'm just a little confused because in the beginning, I think you had testified that you thought some of this proposal was okay and that other parts you had concerns with. And I'm just wondering, and then you said in response to Chairman Staffstrom that some of that was your own opinion. So I'm just wondering, is it the position of the police chiefs that any of this is okay, or is they're opposed to all of this? And if the Police Chiefs Association is opposed to all of this, is there anything worthwhile in having further discussions in trying to reach perhaps a happy medium and moving this ball down the field?
So this is my first time speaking for the CPCA, newly on the executive board. So I don't want to misspeak. I would say that at this point, there needs to be more discussion. There needs to be, like, for instance, having a plate light out. Is that a safety hazard that's going to lead to a bad accident or something like that? Absolutely not. Having one headlight out or tail lights out, it's a different scenario. And that's in my opinion. So I would say it's more, it would be better to sit down and discuss this. We're trying to come on the other side of getting our officers to do more work. And I feel like when we take stuff like this off the plate, it creates a situation where, as a chief, I need to be a leader and get out there. But it's a situation where we'll see less traffic stops when the state itself needs more traffic stops. And again, it's on us to make sure those interactions are positive. I don't want to eliminate interactions. I want to increase them and make sure our officers are having positive interactions.
All right, I really appreciate that. I think this bill is probably not going to go away. It's a House bill this year, so it's got to pass through the House before it even comes before myself and others in the Senate. And it looks like that there's areas where we can reach an agreement. I agree that public safety is paramount, as well as law enforcement, as far as crimes that hurt people or property. But maybe we can sort of disentangle this a little bit better so that folks like Rep. Howard feel more comfortable. But I definitely have had outreach from Chief Fox in Enfield, who I have the utmost respect for, that has overarching concerns about this whole proposal. And yet I felt last year that the advocates made a strong case with data-driven information compiled through folks at Central Connecticut State University. So I look forward to further discussions regarding this, hopefully before we have to vote on it here within the Judiciary Committee. Thank you so much for testifying, sir. Thank you, Chairman Winfield.
Thank you. Comment or question from members of the committee. Representative O'Dea.
Thank you very much, Mr. Chair. And thank you, Chief, for your testimony here today. I mean, look, I saw a couple cars just the other night driving back from Hartford where both lights were out. Thankfully, you're able to pull those cars over, correct? Irrespective of whether this passes.
I believe so.
We've got a problem on our roadways. I want more police interaction in a positive way. So I guess my real question, frankly, is we heard, I don't know if you heard the testimony about the psilocybin. How do you, in your department, test for psilocybin intoxication or tripping, assuming they're tripping without a tripping advisor or sitter, or marijuana? How in your department do you handle that?
Well, that's another issue that's become extremely difficult. You need a drug recognition expert. They're extremely hard to train. Takes somebody off the street for a long period of time to get them trained in that. And they're trained in identification of people on certain types of drugs. When they get really good, they can actually do an interview and an investigation with someone and actually tell them what type of drugs they're on. But you needed, so for instance, when we started to do after the accountability bill, I believe it was part of that, where you had to have a drug recognition expert. You needed people experience at stopping people for so many drunk driving. And unfortunately, we only had a few people that had those numbers. So we had to only send a couple people. So it's extremely difficult. We should have one per shift to combat these types of situations. Unfortunately, we see more of like accident situations where blood's being drawn and then we do a search warrant for the blood. But it is extremely difficult.
And based on your statement here today, I take it you need interaction with the individual in order to determine whether or not they're on psilocybin or marijuana. You can't just determine that by scanning a vehicle from the outside, correct?
Absolutely.
Thank you very much, Chief. Thank you, Mr. Chair.
Thank you. Comment or question from other members of the committee? Comment or question? If not, Chief, I want to thank you for joining us. The good job you're doing in my city. Also, as Senator Kissel indicated, we've had a lot of conversation about this. We even had a bill that was moving through this thing to some degree. So the notion that we need significantly more conversations a little bit baffling to me. But to help out, I will, since we have to meet anyway, I will reach out to you so that we can have that direct conversation. I don't want to hear that in any of these conversations in the future. Thank you, Chief.
Yes, sir. Thank you.
Okay. Next, we'll hear from Chief Pizarro.
Good morning, Chairs Winfield and Sastrom, and distinguished members of the Judiciary Committee. I'm here on behalf of the Connecticut Police Chiefs Association. I'm here to talk about House Bill 5055, strengthening police data reporting requirements. The Connecticut Police Chiefs Association agrees with the overall sentiments outlined in this bill concerning the deliberate falsification of electronic records. And in the spirit of these sentiments, we respectfully offer the following changes to the original draft language, which we believe will strengthen the bill by deterring future submissions of false information and holding accountable those who deliberately submit false information while in the performance of their official duties. CPCA believes that Section 1, Line 3, where it says "as a police officer" should be removed. The removal of this exclusive reference expands the applicability to all public officials who would intentionally falsify these records. We are also aware of suggestions to this bill presented by the Office of the Chief State's Attorney. We fully support those revisions that they've offered, particularly the current language in Section 3 of the bill, which we believe should be removed and replaced as suggested by the Chief State's Attorney, which reads, the Chief Law Enforcement Officer of each law enforcement unit shall promptly notify the appropriate state's attorney of any matter in which such law enforcement officer reasonably suspects that a certificate holder has engaged in conduct that constitutes a violation of any criminal law of the state. Clearly, the chiefs want to make sure that our officers uphold the highest standards of integrity, comply with both Brady and Giglio, which we do all the time now, where we provide that updates to our local state's attorneys as well as federal prosecutors, and that we maintain the public trust. With that, I'd be happy to address any questions you have on this or any issues that you might feel I can be helpful with.
Thank you, Chief. Chief, just real quick, were you here at the beginning when I chatted with the Commissioner of Public Safety?
Yes, I was. I heard most of that.
Okay, so I tend to agree with your proposed change to Section 1, but this obviously is a governor's bill. It comes to us from the governor's office. So could I just encourage the Police Chiefs Association, obviously, to touch base with the commissioner and touch base with the governor's office, and hopefully we can get some agreement on that.
Yes, of course, and we've had some dialogue with other entities as well.
Okay. Yeah, and I, at first blush, I tend to agree with the changes proposed by the Office of the Chief State's Attorney as well. So hopefully we can get this bill tweaked in the way that it works for you guys and works for everybody else. Representative Howard.
Thank you, Mr. Chairman. Good morning, Chief.
Good morning, Representative Howard.
I know you're testifying on behalf of CPCA. We just had another chief. And can you just, when your officers pull somebody over for any violation that they observe or they think they observe, what is the standard that they use? We know like it's proof beyond a reasonable doubt in a courtroom. What is the standard that your officers are trained to use when they observe a violation for a car stop?
Yeah, they're reasonable suspicion. They're out there looking for violations that they reasonably believe have been committed.
So to the chairman's question earlier with the chief, as I understand it then, so if a police officer is pulling somebody over for violation of 1499 where they perhaps have too much tint and don't have the sticker, if they can articulate that a reasonable person would see that and think it's too dark, that's basically the standard they use to stop the car. Is that a correct understanding?
Sure. I would make an analogy with speed, right? Sometimes an officer may not have a speed detection device deployed, and they can do a visual estimation of speed. Clearly we know that a vehicle that's operating above the flow of traffic, that's operating recklessly, is probably speeding, and there are violations that we can cite and certainly issue a ticket or a summons on that for those types of things. I would say the same thing holds true. I heard your analogy. You're being reasonable. You're looking at what is the threshold that we need to enforce at. If you're looking at a car, it's a bright sunny day, you cannot see at all into the car, then clearly that was probably something that would reasonably make you believe that it's not compliant with the law as far as tinting is concerned.
Thanks, Chief. Thanks for the clarification. Thanks for being here. And thank you, Mr. Chairman.
Further questions? Oh, hold on, Chief. Hold on.
Sure.
Representative Fishbein, a little late on the draw here. Representative?
Thank you. Good morning, Chief. I just
Morning,
wanted to
Representative
ask
Fishbein.
you about section 3. And, my concern is that it seems like a quick pull that if there's an allegation against an officer, merely the allegation, it appears, while Internal Affairs may investigate that it's going to the Chief State's Attorney. Do you read that the same way?
Yeah, the original version of that, we do have concerns about the mere allegation, if that's what you're referencing. There are allegations made on a regular basis. There are allegations when someone's taken into custody that things happen We do our due diligence to investigate those when it's appropriate. I would submit to you that every allegation were it to go to the Chief State's Attorney's Office, they would be inundated with frivolous complaints that we could pretty much adjudicate at our level very rapidly and oftentimes do. Those that are more concerning, we would certainly want to bring to our state's attorney. You know, we've asserted that the local state's attorney is the office that we have relationships with now. We do that currently. We provide our state's attorney. I've done it. I know my colleagues in southeastern Connecticut have provided the New London State's Attorney's Office with information regarding integrity issues. Certainly with officers who are being disciplined or terminated for veracity issues. And certainly if there's an officer that's been arrested or subject to a criminal investigation, that is promptly brought to the attention of the state's attorney's office in our judicial district. So I may have gone a little bit beyond the scope of your question, but I think I addressed what you were looking for there,
Yeah,
Representative.
no, I think you did, and I thank you for that. You know, we hear surrounding this bill that it's difficult to do anything with police officers. You know, I'm looking at 53A 157B, which is a similar standard, not having to do with police officers, but it's solely having to do with written statements. Such person believes not to be true. And, you know, in my due diligence for this hearing, I did find a case. It's Charles Bryan versus Post from 2017, where in that case, it was a New Haven applicant to be a police officer, and he was going through the review process, and he had lied on his application various points. And in that particular case, they revoked the temporary certification of that individual. So I don't know that Section 1 is really even necessary. And it got appealed on an administrative basis, and Judge Huddleston did affirm the decision. So, you know, I do share some of my colleagues' concerns with regard to the need for Section 1, but I hope that you have an opportunity to talk to the governor's office about Section 3 and not just the investigatory aspect, but certainly if Internal Affairs determines that there is a violation, then I think referral is necessary, because in the Bryant case, I don't see that there was a referral for that. So, but I thank you, Chief, for your coming here today and engaging in the process.
Yeah, thank you. We will follow up on that, but I would submit to you also, and my understanding is that maybe one of the reasons for this first provision is, as I understand it, having talked to some folks in the state's attorney's office, that maybe that isn't applicable in certain cases when it comes to records, but I will defer to certainly the chief state's attorneys on that area.
Yeah, I think that the concern is that the statute deals with written record, and that some of this stuff, you know, when you push a button and, you know, that's an electronic record. So I just offer that maybe this is just a one-word change, and we add electronic or written record, and we go on with our lives. So, but thank you, Chief.
Thank you.
Thank you, Chief. We're all set. Appreciate it. Next up will be Olivia Ranks.
Thank you.
Thank you, and good morning, and thank you to the members of the Judiciary Committee for the opportunity to testify. My name is Olivia Rinkus. I live in the town of North Stonington, and I'm also employed in Connecticut, and I am an undergraduate at UConn. I'm testifying today in support of HB number 5381, an act concerning the use of police body-worn recording equipment. As a resident of Connecticut, I strongly support legislators prioritizing the need for transparency and accountability among public departments in Connecticut, including law enforcement. I would also like to testify in support of HB number 5324, an act establishing secondary traffic violations. As a Connecticut resident, I am in strong support of reducing the resources being put towards the overpolicing and criminalization of Connecticut's residents. As noted in the 2021 report from the Connecticut Police Transparency and Accountability Task Force, these stops often occur at higher rates for Black and brown drivers in Connecticut, and they increase the chance for contact with police that might lead to harmful or traumatic incidents with law enforcement. This report also describes how these secondary violations are not significant contributors to public safety dangers such as motor vehicle accidents. Rather, this serves as a way of criminalizing Connecticut's residents who may have difficulty in affording to maintain their motor vehicle paperwork. As a Connecticut resident, I would rather see these resources that are being put towards these secondary violation stops instead be put towards other priorities that improve public safety, such as housing, education, healthcare, and other basic needs. I would also like to comment on HB number 5297, an act concerning the decriminalization of possession of small amounts of psilocybin. I am in full support of Connecticut reversing the harms of the war on drugs by decriminalizing the use of substances, especially those with medical or therapeutic uses, and making resources available to those who struggle with the use of substances. However, I would like to ask Connecticut legislators to please remember those who are still experiencing the harms of the war on drugs by fully decriminalizing cannabis and erasing cannabis charges from criminal records and releasing individuals incarcerated for cannabis-related charges. I also believe this bill could go further to decriminalize psilocybin and refer to the suggestions made in other testimonies with more knowledge of this field. Thank you very much for the opportunity to testify.
Thank you. Any comments or questions from the committee? All right, seeing none, we'll move on. Thank you very much for testifying. Next person is Omar Green. Is Omar Green with us remotely? No, then we'll move on. Next person, Aaron Doolittle. Thank you, Ms. Doolittle. If you just hit the button and turn your microphone on, you have your 3 minutes.
Very good. Thank you so much. It's a pleasure to be here this morning, and thank you to the Judiciary Committee for hosting this forum. I am speaking here today in support of decriminalization of small amounts of psilocybin. I am coming to you as a licensed marriage and family therapist. I've been a trauma therapist for 20 years. And I feel that it's time for, the state to sort of embrace some things that were left out in the past due to the war on drugs, never because they were a risk to public safety or anything such as that. The ongoing research and evidence into psilocybin's effectiveness as a therapy is incontrovertible. We did hold a forum here January 10th that did in fact include doctors from Harvard, from Yale, from Stanford. We had some of the best legal minds in the country here to speak. And so I do, absolutely respectfully ask that anyone who's interested in getting more of their questions answered, that they refer to that forum from January 10th, because there is a host of information there that's available. Working in mental health for 20 years, I can't help but notice mental health is often the scapegoat for, crimes against humanity, people acting horribly, mass shootings, et cetera. Psilocybin and MDMA therapy were widely used by therapists prior to the war on drugs with great efficacy. Currently, the federal government is looking to deschedule and allow MDMA therapy to be used because the science and the research and the evidence is there that it works. The VA itself has offered ketamine therapy for years. It also offers a wide range of mental health treatments, but the VA is finding that veterans actually do better with psilocybin than they do with any other medication treatment that they're able to offer. So the VA itself is seeking to be able to access psilocybin for veterans. We are not looking for a marketplace through this bill. We are not looking for any sort of, profit-making options. This is purely to decriminalize small amounts of psilocybin for personal use. I, as a therapist, would like to be able to use it with my patients. People come to me all the time. They say, Erin, I have these mushrooms. What do I do? And so I do trip sit with them. I do support them and guide them through what comes up, which can be very emotional. And that is why we do recommend a trip sitter or someone. If someone is taking a macrodose, that would be at least 3.5 grams or more, which is considered a large amount here. Microdosing, yes, we are talking about 0.5, 0.25 of a gram, so tiny, tiny amounts. Psilocybin is a highly individualized thing. Everyone metabolizes it a little bit differently. So we are looking to avoid some of the pitfalls we've seen in cannabis. We are not looking for a marketplace. We are looking for individual adult people to be able to make a conscious decision to help their mental health, to treat their depression, to treat their addictions, to treat their PTSD. Therapists such as myself should be able to access these tools. And, it's my hope today that I'm able to sort of maybe answer some questions.
If you could just quickly summarize.
And that, I'm here to answer any questions and just to state that, fining people for this does encourage enforcement. And that is not something that anyone really is looking to encourage. And please, thank you so much for your time. Feel free to ask me anything.
Thank you. Any comments or questions from the committee? Seeing none, thank you very much for being here.
Thank you.
Next person is Michael Botello. Michael Botello. All right, Jason Ortiz. Okay, Mr. Ortiz, go ahead. You have your 3 minutes.
Thank you so much. Thank you to the judiciary chairs and all the members of the committee for giving us the opportunity.
If I could stop you, we're not hearing you clearly. I don't know if you can turn up your microphone or turn up the volume.
Is that better?
Yeah, that's better. Go ahead.
All right. Thank you so much to the members of the Judiciary Committee. My name is Jason Ortiz. I'm the Director of Strategic Initiatives for the Last Prisoner Project. We are a 501c3 organization that seeks to rectify the harms done by the war on drugs by providing retroactive relief for all of those.
Yeah, we're still not hearing you very clearly. Want to try again?
Is this better? I'll try without my video on.
Or just speak up.
Can you hear me now?
Yeah, that's a little better. Go ahead.
All right, we'll do it just the audio. So again, my name is Jason Ortiz. I'm the Director of Strategic Initiatives for the Last Prisoner Project. We are a nonprofit organization that seeks to rectify the harms done by the war on drugs by providing retroactive relief for those who have been incarcerated for cannabis and now other crimes. And we're here in support of 5297, the decriminalization of psilocybin. We want to make sure that as we have discussions around decriminalizing any substance, that we are including things like expungement, resentencing, and addressing issues of probation and parole to make sure that we are continually incarcerating folks for simple possession of any drug. And for this particular bill, we are talking about decriminalizing psilocybin that is produced in a very natural form in psilocybin producing mushrooms. And currently, you can go to jail for upwards of a year. If you happen to be in a location that is near a school zone, there's a mandatory minimum of 2 years. And so we are talking about a simple handful of mushrooms that could potentially incarcerating folks for years of their life. And so as we have this conversation of what is effective policing, what is effective ways to address safety in society, magic mushrooms and psilocybin producing mushrooms are one of the least harmful substances on the planet. And so the idea that we would actually be threatening folks with multiple years of their life for possessing a handful of a mushroom is not in the interest of public safety. We really think that this bill is a great start as we want to move forward with reducing our prison population for simple possession of naturally occurring substances. But in order to do that, we do need to include broader decriminalization efforts, including things like home grow and letting folks be able to produce these psilocybin producing mushrooms in the safety of their own home. So as we continue to talk about exactly what is the proper amounts, we do want to think about, as somebody uses this substance, the amount that they're going to be possessing will be used over a course of multiple sittings. And so 14 grams is a relatively small amount of psilocybin mushrooms for folks to be able to use over a long period of time. And so we do suggest expanding that to at least an ounce and making sure that everyone that is currently discussing the potential positives and benefits of psilocybin, that they're not having to, risk arrest in order to do so. What we're doing now is we're actually making criminals out of veterans and senior citizens that are trying to expand their quality of life and deal with very difficult circumstances. So by continuously criminalizing these folks, we are forcing them into the illicit market to procure things that are going to help them deal with very difficult parts of their life. So we encourage the Judiciary Committee to support this bill, move it forward, add retroactive relief measures, and make sure that we're encouraging everyone that is curious about this type of substance to do so in a way that won't land them in prison. So thank you all for your time. Please add home grow and retroactive relief to this bill, and we look forward to providing any technical
All right.
assistance that may be.
Thank you very much for your testimony. Any questions or comments from the committee? Seeing none, thank you very much for being here. Next person is Kristen Hitchcock.
Is this on?
And yes, you're on, and go ahead with your 3 minutes.
Okay. Good afternoon, and thank you for your time. My name is Kristen Hitchcock. I'm a senior counsel at the Policing Project at the NYU School of Law, and I'm testifying in support of HB 5324. The Policing Project works with lawmakers, community groups, and police departments to create and adopt policies to ensure transparent, effective, and ethical policing. We have also conducted research on the public safety impacts of reducing low-level traffic stops, and we've drafted model state-level legislation. There are over 20 million traffic stops made each year across the country, and a lot of these stops are for low-level violations that dominate law enforcement resources. Yet there's strong evidence that traffic stops for minor violations are not an effective way to reduce crime or car crashes. But there is evidence that they create potentially dangerous situations and disproportionately impact communities of color, which erodes trust in law enforcement. These national trends are also present here in Connecticut. CTRP3's 2022 Connecticut traffic stops analysis indicated that Black and Latine drivers are respectively 39% and 68% more likely to be stopped for over 30 minutes in a traffic stop compared with other drivers. HB 5324 makes progress towards achieving the public safety benefits of reducing low-level traffic stops. Prohibiting law enforcement officers from stopping a vehicle only to enforce specific equipment or administrative violations reduces racial disparities in traffic enforcement and better allocates police resources to those stops which truly impact public safety. Jurisdictions that have adopted similar secondary stop laws or policies have seen dramatically reduced racial disparities in traffic stops and searches. In the months following the passage of Virginia's ban on pretextual traffic stops, the rate of Black drivers searched during traffic stops fell by 40%. And after Philadelphia and Oakland limited low-level traffic stops, the rate of Black drivers stopped fell by over 40%. In addition to reducing racial disparities, limiting traffic stops for secondary offenses allows law enforcement to focus on more dangerous driving behaviors, which can lead to safer roads. After Fayetteville, North Carolina reduced low-level traffic stops, the overall car crash rate, the rate of crashes with injuries, and the rate of fatal crashes all dropped. And here in Newington, Connecticut, almost half of traffic stops were for defective lighting violations, but when they limited stops for non-moving violations, the stops that resulted in a DUI arrest more than tripled. And so limiting stops for low-level violations led to a dramatic increase in the number of impaired drivers that were stopped. And with HB 5324, these benefits can be extended statewide. By creating clear guidelines on how and when officers may conduct traffic stops, HB 5324 makes progress towards ensuring effective and equitable policing in Connecticut. By adding additional categories of secondary stops, ensuring robust enforcement mechanisms, and addressing local preemption, the bill could go even further towards reducing racially disparate traffic policing, and we encourage the committee to report favorably.
Okay, thank you very much for your testimony. Any comments or questions from members of the committee? Representative Howard.
Hi, ma'am. Did you come here from New York?
I did.
Oh, thanks for making the trip. So you said something that was interesting to me. You said that your data is that these low-level violations dominate traffic stops. So do you have data that police officers in this state or in this country are stopping operators significantly more for equipment violations than moving violations?
I do have data responsive to the amount of financial and labor resources that are spent on traffic enforcement. And I think that I've included that in my written testimony, but I'm happy to confirm that and submit further research if I have not.
All right, I'm mostly asking this. Out of 100 traffic stops, right? If we look at a percentage, out of 100 traffic stops, what does the data say? What percentage of those are moving violations and which percentage of those are on this list? And if you don't know right now, that's fine. But if you could get that to me, that'd be an interesting number.
I'm happy to follow up.
Thank you so much.
Thank you, Representative Howard. Any other questions or comments from members of the committee? Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon. Yeah, it's just afternoon. Good afternoon. How are you doing?
Good. How are you?
So I also wanted to ask you, you'd said something about disparity. I think you talked about Virginia and that passing certain secondary traffic stops had decreased the amount of
Racial disparities in both searches and stops.
Sure. So were you part of that study, or that's the study that you reviewed?
That's a study that I reviewed. If you are interested particularly in the policing project studies, I'm happy to talk about our work in Nashville. We worked with the Stanford Computational Lab to review 5 years of traffic stop data in Nashville, Tennessee. And we found that less than 1% of their low-level stops resulted in an arrest or the discovery of contraband. But when officers made stops based on a reasonable suspicion of criminal activity, those stops were more than 8 times more likely to result in an arrest or the discovery of contraband. And during that time period, Nashville steadily decreased traffic stops, but crime rates remained flat. And
I'm focusing on your representation to our committee
Mhm.
that the racial disparity was affected by this. And the reason why I question that is I don't know how anybody could calculate that unless in a particular year, they're able to quantify the number of people on the roadways that are Black, Hispanic, we'll just take those 2 minority categories,
Mhm.
as well as white, okay? So they take, the year 2000, 365 days a year, there were this many people of this race on the roadway, there were this many traffic stops. 2023, there were this many people of those particular races on the roadways, because that's part of quantifiable data,
Mhm.
right? And then you compare the amount of stops to those races and then show that there's less, right? That's the calculation to show an effect upon race as a result of a change in law reducing stops. So are you telling me that there's a study out there that has done that?
Well, I don't want to speak to this particular methodology of the studies, so I'm happy to follow up and send you more information responsive to that. But I can tell you that across the country, Black drivers are 20% more likely to be stopped nationwide than white drivers. And across the country, after a stop, Black and Hispanic drivers are both more than twice as likely as white drivers to be searched. And those same disparities are present in Connecticut as well.
Okay, but I'm focusing on the legislation that's before us, right?
Okay.
So the legislation before us would arguably reduce the ability of an officer to stop a vehicle.
Mhm.
And what I've heard from you as well as others is this law, because there'd be less stops, would address racial disparity.
Mhm.
And I'm trying to, because I haven't found a study in which they were able to take that initial subset, pass the laws in a state, take the same subset and apply that effect to that conclusion. And that's what I'm trying. I hear it. I hear it in the analyzation, the rhetorical, but I'm still looking for that study. So are you saying there's a study that says that, or?
I'm not sure if I'm quite following what you're looking for in a study, but I did find that the Connecticut traffic stops analysis data was very indicative and does break down on their website the difference, the disparities in both what violations Black and Hispanic drivers are stopped for and the lengths of those stops. So I'm happy to send that data. I think that's what you're looking for.
Well, I hear from, you had mentioned that in Virginia, there was an effect because they passed certain laws and that this helped a racial aspect. So
Yes.
just to bring it back where I was.
Okay.
In order to do that calculation, you would have to say on a particular day, let's say, there were, and I'll bring it down to the micro,
Mhm.
there were 5 people of Black race, there were 3 people of Hispanic race, there were, let's say, 7 people of the white race. And on that particular day, there were 3 of these traffic stops. Now, laws get passed, and as a result of that, 4 years later, there is the same amount of people of those races on the roadway, and there's an effect and it proves that racial disparity is being addressed. That's basically the calculation, and that's what I've been looking for.
Right. I understand you to be asking me what is the calculation that the research studies that I mentioned in Virginia, Philadelphia, and Oakland applied. And what I can say is I can follow up with you about that, but off the top of my head, I can't tell you what research methodology they used.
Okay, thank you. Thank you, Mr. Chairman.
Thank you, Representative Fishbein. Further questions, Representative Howard, for the second time.
Thank you. Sorry, I'm trying to move quickly. I know people are waiting, but you said, you're an attorney? It says senior counsel.
I am.
Okay, I just want to make sure it's because, so you said, I think what you said to Representative Fishbein at the beginning of that was that when operators were stopped for reasonable articulable suspicion, they were, I think you said 8 times more likely to find contraband. Was that right?
In Nashville?
Or, yeah, maybe it was
Yes.
in Nashville. All right. That brings up an interesting point to me because reasonable articulable suspicion is not based on a motor vehicle violation. It's based on this vehicle is coming from behind a closed business at night, those sort of things, right? That's what the reasonable articulable suspicion stops are, right?
I don't know that I agree that a vehicle coming from.
What is a reasonable articulable suspicion stop?
Having a reasonable suspicion that a crime has been committed. So I don't know that I would say a vehicle coming from a building at
Okay,
night.
so if all right, I didn't mean to put you there, but if we're in agreement that a reasonable articulable suspicion stop is based on facts and circumstances that leads an officer to believe a crime had been committed, absent any motor vehicle violation, can we agree on that definition? Without the necessity of a motor vehicle violation?
Yes.
Okay. Now, in 1996, the Supreme Court in Renville, US said that regardless of the intent of the stop, a stop is per se reasonable if a violation existed, correct?
Oh, I can't tell you what that.
Okay, that's okay. So it did, right? But my question becomes, do you have a concern? Because reasonable articulable suspicion, and we almost did it by mistake, is very debatable, right? Do we have a concern? Is it a fair concern that if we take these 16, 17 violations out, that in a suppression hearing, a defense attorney could argue that the reasonable articulable suspicion, we're opening a door for them to argue that even if one of these violations existed. So currently under law, if a police officer in this state stops a vehicle for reasonable articulable suspicion and has an out headlight, well, the opportunity for defense to argue that the stop was bad is kind of out the window because the headlight's out, right? But now if we pass this, we're creating that and potentially dividing the contraband that we take off the streets by 8. You follow that?
No, I'm sorry. I can't follow you down that hypothetical, but I can tell you that this bill doesn't remove an officer's ability to make a stop for reasonable, for a reasonable.
I understand that part, but what I'm saying is if I'm a police officer in this state today and I see a vehicle and I have reasonable articulable suspicion to believe they were involved in stealing catalytic converters, for example, and I pull that car over and it leads to a search. I don't want to go down that road, but it leads to a search and I seize a bunch of stolen property. And then a defense attorney could argue, well, the facts and circumstances that you articulated to stop that car were insufficient, and therefore everything you seize is fruit of the poisonous tree, and that stop and everything resulting is out, right?
Yes.
But if that particular car also had an out headlight, that sort of suppression argument goes out the window now because the violation existed. So that contraband stays in, right?
I still can't follow that, but
Okay.
I can also tell you that these stops for minor traffic violations do not lead to often lead to the discovery of a crime or contraband.
Okay. Well, thank you so much.
Thank you, Representative Howard. Any further questions or comments from the committee? Representative Osborne.
Thank you very much for being here today. And I just want to follow up on one point you just answered to Representative Howard. You said that these stops for minor traffic or minor vehicle violations do not often lead to the discovery of contraband or other impermissible items. Can you define or can you quantify often?
Yeah, I can tell you what we can see in like certain case studies. Research indicates that these type of low-level stops do not lead to finding evidence of a larger crime. Stops for non-moving violations in high crime areas in Nashville, Tennessee, only led to serious criminal charges in fewer than 1% of cases. In San Diego, only 1.3% resulted in any arrest.
Do you have any studies that happened here in Connecticut? Because this bill is here in Connecticut.
Certainly, and I have attached those to my written testimony, so I will make sure that I've done that. And
Do you have that information with you right now?
I don't believe that I have specific numbers in front of me as to that right now.
Did the study that you say is attached to your written testimony in Connecticut, did those studies quantify that number? How often?
I believe so.
And to your knowledge, how often do any stops lead to? So if the motor vehicle problem stops only result in 1.3% in this other state that you're talking about, how often do all stops result in the discovery of?
I'd say overall, just generally, these stops, the harm of these stops far outweighs any benefit.
But that wasn't my question.
Okay.
My question is, if they only lead to using that one study in that one state, if motor vehicle low-level offense stops only lead to finding contraband in 1.3% of the cases, how often do other types of stops? So how often do reasonably articulable, I don't even know what the phrase was, reasonably articulable suspicion? Is that it?
Yeah.
How often do those stops lead to?
Okay.
What are the percentages compared? I mean, maybe they all are only 1.3%.
I understand your question. No, the percentages of stops that are based on a reasonable articulable suspicion that a crime has been committed far more often lead to the search of the discovery of contraband or an arrest. And I can give you the exact numbers of that.
You can quantify that for me? That'd be
Yes.
great. Thank you so very much. And thank you, Mr. Chair. Mr. Vice Chair, Mr. Guardian.
Whoever I am. Thank you, Representative Osborne. Any further questions or comments from the committee? Representative Blumenthal.
Thank you, Mr. Vice Chair, and thank you for being here today. Just a quick question that kind of follows up on Representative Howard's line of testimony or questioning. I just wanted to clarify one thing, and I don't know if you have the answer to this question handy, but those reasonably articulable suspicion-based stops, would they include a more major moving violation like a speeding violation or some sort of reckless driving, or are they only stops related to the crime or contraband that's ultimately?
No, they would include those more hazardous driving behaviors that we also know to be related to car crashes, like you said, the excessive speeding rates and impaired driving.
Okay, so really we're talking about, it's just these secondary, more minor driving infractions that are a much lower percentage bet, I guess you might say, indelicately, for police action, as opposed to other more serious driving offenses.
Yes, the sorts of low-level stops that this bill specifically seeks to limit.
Okay, thank you very much. Thank you, Mr. Vice Chair.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us this afternoon. Mark Guckel.
Yes, good day, honored members of the Judiciary Committee. Thank you for having me here today. I'm here to speak in support of the bill to decriminalize small amounts of psilocybin. It's my hope, just with what the committee has heard today, that people realize that there are more important resources for the police, for law enforcement, to use their resources rather than to be arresting people for a substance that, if we knew what we did today, we would have never made it a Schedule I controlled substance. As I had mentioned, my name is Mark Guckel. I'm a Connecticut Community for Addiction Recovery coach, professional, and curriculum facilitator. Over the past year, I've done a lot of speaking about this to include for Connecticut DEMAS. And the reason I do is because my life was transformed by psychedelic medicines. I struggled with drug addiction for the better part of my life. I was unable to stop using heroin and cocaine. And after the loss of my dad, I inherited $2.6 million. And I'd been in recovery for a little bit then, but I ended up using again. And I ended up stuck in my bathroom smoking $3,000 worth of crack every single day. And by a fluke, I found a video on psychedelic medicines online, and I was desperate and dying and turned to them. At first, it was Ibogaine, then ayahuasca, and today I use psilocybin to maintain my recovery. And and what I'd like to reflect with that is it's not something that I use regularly. It's been almost 4 months since I used psilocybin on my own. And I found nothing else that's helped me not only to sort through some of my mental health issues, that obviously helped me to stop using drugs, but that's also helped me to become a better person. What I'd like to reflect with you is right now there are 26 states that have legislation. New Jersey, right now, they have something that's very similar to this. As far as Representative Fishbine's comment, it seems like the government is giving states to make their own decision making when it comes to this. Because right now there are successful service centers that are operating in Oregon. They're getting ready to set up similar service centers in the state of Colorado. And I did hear one question that was asked about you have a chance, go to the University of California Center for Psychedelics website, and you can Google. There's a clinical trial locator, and it also shows you every single trial and research study that's ever been done before. There's a lot of knowledge that's out there. But what I can say, and what I'd like you to consider is there are people who are going to be just like me, who are desperate, dying, that want to try something new because our system isn't working.
Mr.
And by
Guckle,
giving them the latitude to use this,
your
yes,
time, your time. is still up.
absolutely. I thank you for allowing me to share.
Thank you. Comment, question from members of the committee. Comment, question, Representative Osborne.
Thank you, Mr. Chair. Thank you very much for being here today and testifying and sharing your experience with the use of psilocybin in your recovery. I heard from a constituent today who is a strong proponent of eventually decriminalizing psilocybin so we can more fully explore its therapeutic benefits. And one point was raised to me, which is, if we're decriminalizing psilocybin right now, but we're not decriminalizing the ability to actually go buy it somewhere, we're not decriminalizing home grow, are we actually putting the cart before the horse with this decriminalization bill, in that we haven't set up that robust regulatory framework that would permit people to, or that would keep people from unwittingly breaking other laws in order to possess the psilocybin that we're creating? Do you have any concerns about that, sir?
Honestly, I think that people are going to find psilocybin no matter what. If you Google buy psilocybin microdoses online, you'll see a whole list of vendors. You'll also see a lot of magazine articles which give reputable sources. And while I'm not in Connecticut right now, here in Florida, like 9 months out of the year, psilocybin grows naturally. And this isn't uncommon. Psilocybin containing mushrooms grow all around the country, and there's fairly easy access for anybody that's determined to get it.
Thank you very much. Thank you, Mr. Chair.
Thank you. Question or comment from members of the committee? Question or comment from members of the committee? Seeing none, Mr. Guckle, thank you very much for joining us this afternoon.
Thank you.
Next, we'll hear from Brian Mezek. Good afternoon. Good to see you again. Push your button. You may have your 3 minutes.
Okay, there we go. Good morning, everyone, or good afternoon, rather. Senator Winfield, Senator Kissel, Representative Fishbein, and other members of the Judiciary Committee. I'm Brian Mezek. I'm a Connecticut State Marshal. I'm president of the State Marshals Association. We're here to give testimony on HB 5379, an act concerning the duties of state marshals. We support this bill. It's effectively an operations bill concerning the many things relating to Connecticut State Marshals. Well, we put in some written testimony also, but amongst the bill's various parts, we just want to highlight a couple of things that we believe it will do to make service of process in Connecticut even better. First, it would increase training, education, and communication for state marshals. That's a provision that we strongly support. What we're talking about here is continuing education. Many other professions, real estate appraisers, attorneys, real estate agents have continuing education. The state marshal should have that. We deal with a lot of different and broad and complex issues. One of the goals of our group is to increase professionalism. That's why we're up here today. Also, the bill would improve recruitment and the selection process for future Connecticut state marshals. We have a current need now for good people to take on these jobs. I was up here yesterday in another committee with some of my colleagues testifying about the coming retirement wave. Almost 60% of state marshals are over the age of 60. There's only 13 of us under the age of 40. I'm one of them. So there's a current need now to put on good people, diligent people, professional people to take these jobs. There's need, especially in Fairfield and Middlesex counties. So this bill would allow the Marshals Advisory Board and the Commission to work better together to put on good people. The bill also improves and creates a dynamic where there'll be more consistent execution of child support orders. Those are capious warrants. The bill, like I said, would leverage the State Marshals Advisory Board, which is the way the system was designed with Public Act 0099, that 24 elected marshals around the state would have more input into the system. The bill also addresses timely payment for our state marshals from the judicial branch for things like service for indigent people, restraining orders, protective orders, capious warrants. It also does some other things like provide a mechanism for what to do if a state marshal dies in office, what to do with their trust account. That's something that's come up from time to time, but a rare event. And then just one other thing I want to point out in section 7 concerning the increased professional standards. We do have one suggestion in looking a little bit more closely at this today in subsection 3, that it say knowingly, that no state marshal can knowingly make a false or illegal return. We wouldn't want like a typographical error in the marshal's return to come into play under this section. This section is obviously referring to intentional conduct outside the bounds of integrity. And we do have a good system that largely is free from motions to dismiss and other sewer service issues that come up in other states. We have a good system. So we support this bill. We urge your support. Our courts, litigants around the state, and our state marshals depend on the system operating well, and it improves the system. So I'm happy to answer any questions you might have.
Thank you very much. Representative Fishbaum.
Thank you, Mr. Chairman. Nice to see you, Brian, again. I know we talk, want to go through some of the aspects of what's before us. The knowingly aspect, I do agree. You don't want somebody to get caught up in something that they didn't know of. But I guess that dovetails into the education aspect.
Mm-hmm.
So I know you and I had talked about a case that I had a few years ago where the marshal put the papers in the mailbox, and ultimately the court vacated that case. Now the marshal should have known better, right? So how would that work with this? Because on that, and it was a restraining order case, and the marshal affirmed that he served by abode. And as you and I both know, that is not abode service. So how would that particular fact pattern work into this language?
Well, that's an issue that comes up in the day-to-day work of service of process. If we have a setup where we're effectively training our marshals and then they go out to do their career and they're never continually educated year to year, what the bill would envision would be the commission and the State Marshals Advisory Board working on an annual program to maybe have the marshals come in one day a year and address maybe some of the issues that came up in the past year. If that happened to be one of them, that would be something that would be addressed in the training. We don't have that set up right now. So, obviously we know about that story because we discussed it. That would be something that could come up throughout the system and everyone could be educated on it.
So does this language incorporate a requirement that if a marshal does not attend particular training, that they would be demarshalized?
Yeah, so the commission already has purview over professional standards. This would just particularly clarify that they have it over continuing education. They have authority over education. This would sort of empower them and empower us to put together that program for the future. But yes, it would be a requirement for them to participate.
Maybe you don't know the answer. What is the singular of capious?
Anecdotally, I would say KPI, but I don't think that's correct.
That's right,
Yeah.
right? That's what I was thinking last night. It's actually capious is the singular and capiouses is the plural, just so that you know. But
I do use KPI, but I don't think that's correct.
bringing us to section 3, section 3 contemplates having less marshals.
Okay,
And-
so this section here is really a relic of the former sheriff system. It hasn't been touched in some time. The number is not, the current statute is not a realistic number. It's not a real number. So just for context, the bill would contemplate setting the maximum number of marshals to 230. We currently now have 160. In our estimation, the appropriate number is probably around 185 to 190. So there's plenty of room for the current needs now and the current needs in the future. Just the current statute of 318, there would never be enough work to even have all those appointees.
So why reduce it? And let me just put together my thought process, and this is where capias comes up. Not all marshals can serve capiases, right? You need additional training, and usually service of a capias, which for those following along at home, that's like an order from a court to a marshal to go pick somebody up and bring them to court, right? And you usually use 2 marshals to serve and effectuate a capias because sometimes there's bad things that happen. So why would we be reducing the number? Why not just have the ability to have more marshals?
Because effectively you wouldn't be able to put on appointees just to do capias. We have a responsibility to the whole system. There's always been, since going back even to the sheriffs and the inception of the state marshal system, there's always been a subset of marshals that do that work. We can make an argument whether there should be more. The current statutes already allow a minimum number percentage to be allowed. I don't know if the commission's exercised that authority before, but the 318 number is way outside the scope of what the system could handle, notwithstanding the capias questions. I was up here yesterday also concerning another bill about adding a healthcare benefit to increase recruitment, diversity in the system. What we wouldn't want is people being appointed and just holding a badge. We need working people. So it's setting a more appropriate level for the system. The existing statute goes back, I think, to 1994. It's not a realistic number. It was a number where the high sheriff was appointing people to hold badges and not do the work. What we want is the statute to be updated and reflective of the current system. And I have the historical numbers to show that we've never even exceeded or come close to that number.
So how many marshals do we presently have in Middlesex County?
It's lower than it should be. There's a current need to appoint more. I think it's sub 10, might be 7 or 8.
Yeah, and just so everybody knows what we're dealing with here, the marshals operate on a county system.
Correct.
So when you give us this very large number, a marshal whose office is in Litchfield can't serve papers in New London, can't serve papers in New Haven. So we're looking at a county system. And the problem, and I talked to you about this where I had a case in Middletown Court and I had an emergency order from the family court because a child was in danger and I couldn't get a marshal to serve it because this one's on vacation, this one's out serving a capias, and he's got some other guy with him, and you said sub 10, right? So I think there's like 9 marshals that have, out of the whole state of Connecticut, that can serve papers in that county. And now we're restricting it even more.
Well, in some of those small counties, like if I could use Litchfield County, for example, because I particularly know more of what's going on there. I think there's 10 marshals in Litchfield County. There's only work to accommodate maybe 3, maybe 4 full-time marshals. So yeah, I know you ran into an issue in Middlesex County. We do need to put on more appointees in Middlesex County. But even if we were to put on 13, there would not be enough work to take on those jobs. And sort of other sections of the bill add a more robust hiring and interviewing process. What we're looking for and advocating for is people to take these jobs on as careers, not as a side job or a job after a retirement or those who are holding a pension. We're looking for people to take on the job as careers, as a full-time marshal with a responsibility to the system and the badge. And the bill would do it. And within these numbers, it would also work.
I just don't see I really don't see a benefit to reducing the total possible numbers, because they do provide a service. The other thing that marshal, there's always a marshal who's assigned to, I think, every courthouse in the state, 4 PM every weekday to come there and talk to individuals who have restraining orders that were granted during the day. You know, that's taking marshals away from other stuff as well. They're not there for those emergency ex parte orders or stuff like that. So I don't see a harm in keeping the number. I understand that if you say there's only going to be 10 in a county, then that is more apt to have somebody have it as a career. You know, liquidation by having 20 marshals in that particular county may say, well, there's not enough business to go around and therefore it's going to be a part-time job. I have it. I got it. You know, but the other thing that's restricting here is presently under the law, in order to be a marshal, you only have to be a registered voter in that county. I think this language requires that their primary residence is also, you know, which it should be. If you're registered to vote in that county, right, you should be living there.
Correct. It's a further elaboration of what the existing dynamic is, because to be a registered elector, you obviously have to be a bona fide resident in the town where you're registered to vote, or other issues would come into play.
And I know there's some individuals out there that are not abiding with the residence, but they are registered to vote there, and you know, but
This would allow the commission, upon looking at somebody's background when hiring, make sure that other issues don't come up down the line. So it's a proactive elaboration.
I understand, but it's all, I think it's gonna affect some people's employment if they come into line, and which is gonna reduce the number also, at least in the interim.
Yeah, and I understand the current issues that you had in Middlesex, and I also brought up Fairfield County. That's why I mentioned it in my testimony. The marshals know that there is a current need now in that county and in Fairfield County to add more appointees.
What are they doing to have that happen?
Lobbying the commission to put more marshals on in the class. Really in the next appointment, we would like them to target Middlesex and Fairfield County. So for example, we added more marshals in 2022. When I got on 10 years ago, there were over 1,000 applicants for the job. This current recruitment process, we got 145 qualified applicants. There's a background and interest. In Fairfield County, the system was interested in putting probably more than 10 marshals on in Fairfield County. We were only able to put on 2. That same dynamic happened in Middlesex County. So I'm confident with this bill and a lot of effort and attention on it that those counties will be targeted and some of those system issues will be resolved.
Thank you. I also want to ask you about section 5 and particularly P, and I'll read it to you. Unless otherwise prohibited by law, the commission shall also operate as the state agency for the state marshals in relation to any benefit, right, privilege, or function conferred to state marshals, which seems like collective bargaining.
No.
Okay, so what is the intent of, or the state, that the commission will have guidance over those areas, which seems like over the areas of hiring, firing, all that stuff.
So state marshals are more than just a person that holds a license. We're sworn to the state constitution. We have arrest authority. We have peace officer status. We have certain obligations to the system. The State Marshal Commission was, when it was created under Public Act 0099 in 2000, had a charge for professional and other standards. They also do discipline. The commission has to move beyond just viewing itself as a discipline and policy-making body. There's other things that come into play in the system for state marshals. State marshals, for example, not getting paid timely by the judicial branch. State marshals have the option of purchasing into the state health plan, distributing that information. There's certain things system-wise that the commission has to be able to do to manage an effective service of process system in our state. This section would just specifically state that the commission does more than discipline. It certainly had no collective bargaining intention. And we, in fact, are not state employees.
there's also an expansion of the commission here for and compensation for the executive director. Is that part
Great.
of this? Also?
So what this would say is, that the commission is to be, its staff is to be managed by a director, staff attorney, and investigator, which are current employees within DAS. Those positions are already filled. What this section would do is just enable the commission to have some stability in its operation. This isn't adding anything different or anything new, rather.
Well, it's adding a lot of additional language. Says the commission shall appoint a director, staff attorney, investigator, and additional staff. So those all exist presently.
Correct.
And who appoints them?
The commission operates as an independent sort of agency, and these people are report to the commission chairperson.
So we don't have law right now that says that the commission shall appoint?
Correct. And the staff configuration has been in different sort of configurations throughout time. Sometimes it only had one staff attorney there, or it had a part-time director who shared another job within DAS. The marshals viewed that as not the most stable system, and we're interested in some stability and good effective process throughout the state. So these are positions that have been filled somewhat recently, but that's the current staffing of the commission at this time.
And I think it says that the commission shall determine the compensation. But is that within, I didn't see the language within regular appropriations. So my concern is that we have language that says the commission has its power to hire someone. The commission determines whether or not, or what, the individual is paid, but
I think the language, I forget what section it's in. If you could point it to me, I can pull it up. I think it says in consultation with the commissioner of the Department of Administrative Services.
yeah, director, it's line 199. Director shall serve the pleasure of the commission. The salary for the director shall be determined by the commissioner of Administrative Services in consultation with the chairperson of the commission. So is it your representation that that is the sort of the executive branch portion of permitting the salary?
Well, the commission operates for administrative purposes only within the Department of Administrative Services. So whatever legal construct that is, the employees are going to have to be paid by the agency. So it's going to be determined by the agency that's housing the commission, which is DAS.
Okay. And the last thing is lines 407 through 410. No state marshal as a matter of practice shall receive, direct, transfer, control, or solicit process from an attorney at law for which a state marshal cannot lawfully serve within the state marshal's appointed precinct or extension of precinct. Is that an issue presently?
Yeah, so the system is designed that I'm appointed in New Haven County. I have authority in New Haven County. I have no authority in the other counties except for a second service on a multi-defendant writ. So I can't take into my office, get like a law firm that has a volume amount of work. And that law firm maybe from out of state says, we want to use you only. We want to send you boxes and boxes of process. And then you, the New Haven County Marshal, you're going to distribute and control that work to the other marshals. That system was ended when we got rid of the high sheriffs. So this would effectively prevent warehousing and marshals really operating beyond the scope of their authority. I'm a proper officer within my precinct. If you had process from Middlesex County, it wouldn't be appropriate to send it to Brian Mezek, Connecticut, New Haven County State Marshal, and then I make a determination about how to distribute it. So this would just say, as a matter of practice, that's not allowed. It would certainly allow if a writ got sent accidentally to another marshal, there was confusion about the county lines. But in terms of warehousing or volume amounts of work, this isn't allowed. There's been prior attorney general opinions on this going back to foreclosure work about warehousing work. So this would just put it in statute what the dynamic that already exists.
Another issue along these lines that we had talked about is when a courthouse issues, let's say, a restraining order and the respondent does not reside in that particular county. My well, how does that courthouse get the paperwork to a marshal who can serve in that county?
Right, so the courts do not, as a matter of practice, coordinate service of process. They'll give it to the applicant. Then by policy, there's an existing statute that the commission has, and I'm paraphrasing here, has responsibility for the equitable distribution and expeditious service of restraining orders. So by policy, the marshal in that courthouse is required to take that paperwork and coordinate its transfer to the proper officer around the state. I'll note here, we don't get paid to do that. That's part of our obligation to the state. So this in no way would prevent that, because this is concerning attorneys at law.
Okay, the exception being the scenario that we're talking about is receiving it from a courthouse. So
right,
that would be permitted,
yes,
and that marshal is taking on the duty to get that paperwork to a marshal in the particular county.
Correct. So for example, if it came out of the Middletown courthouse and it needed to be served in Wallingford, the marshal assigned to the Middletown courthouse by policy is required to take that restraining order and coordinate it with whoever is on duty in New Haven County, probably in the Meriden courthouse or another New Haven County state marshal.
All right, I think we're going to be talking further about that process, but it's really a little bit outside the scope. So thank you, and thank you, Mr. Chairman.
Thank you.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? Seeing none. Thank you very much for joining us today.
Thank you.
Good to see you again.
Thanks.
Next, we'll have Lisa Capitani.
Am I all set, ready to go?
You are. You may begin.
All right. Thank you, Senator Winfield and members of the committee. I'm here today to speak in opposition to Race Bill 5297, an act concerning the decriminalization of psilocybin. While opposed to this bill in its substance, I am in full support of true decriminalization of psychedelic plant medicines, including psilocybin. I have been serving my community as a registered nurse in Connecticut for almost 19 years. My personal story, which I detailed in my written testimony, is one that demonstrates the failures of the healthcare system. Even as a nurse, my attempts to gain relief from chronic pain and the symptoms of PTSD via the healthcare system only further compounded the trauma I experienced both on and off the job and in seeking care. Working through the early days of the pandemic deeply wounded me. By 2021, I had lost my job due to an injury and was in a very dark place. I didn't want to be a nurse anymore. I could barely take care of myself. I was told to apply for disability, and I was in so much pain that I didn't want to be alive anymore. If I had waited for federal action on plant medicine and hadn't gone outside the system for alternatives, I wouldn't be. My exploration of plant medicine saved my life. It's hard to explain in a 3-minute statement, but the short version is that my intentional exploration of plant medicine allowed me to reframe past trauma, grieve and accept losses so that I could let go of being a victim, and gain a sense of self-worth that allowed me to heal. And I healed in ways I was told for over a decade were not possible. I would not have been able to do it without plant medicine. I was running out of the will to fight any longer. And it's not just about the molecules. Finding a community has been an integral part of my healing as well, and helping others heal in a community setting has become my passion. I've seen more healing in these circles in the last 3 years than I did in 15 at the bedside. I do appreciate our lawmakers recognizing the evolving understanding of this medicine. The convincing early research on psychedelic therapies has been around for decades. The current explosion of research, including the FDA's breakthrough therapy designation for psilocybin treatment for depression, cannot be ignored, and they sound revolutionary. But just like aspirin was a revolutionary advancement in pharmacology at the time it was patented, people had been using salicylic acid-containing plants as medicine since the Assyrians recorded the recipes on clay tablets 4,000 years ago. While our modern-day use of psilocybin mushrooms looks different than it did in indigenous cultures that began this work, there is nonetheless a strong culture associated with using mushrooms for personal and spiritual growth. This community deserves to be allowed to do this life-changing work without fear of being labeled criminal. This bill perpetuates criminalization via fines, which makes it likely that enforcement will increase and further sustains the war on drugs, which we all know never stopped drug use, destroys lives, and stigmatizes users. My written testimony contains several recommendations to improve this bill that I sincerely hope the committee will consider. Thank you very much for your time today.
Thank you. Comment or question from members of the committee? Comment or question? Now, thank you very much for joining us and providing us with your perspective.
Thank you.
Robert Goodrich.
Yes, good afternoon. Co-chairs Senator Winfield and Representative Stafford. My name is Robert Goodrich, and I'm the Executive Director of RACE, a Waterway-based education advocacy organization. And today I'm here to provide testimony in support of HB 5324. And mostly because we need to jettison the public safety strategies that are direct descendants of the war on drugs. And these types of policing strategies lead to poor community relationships and increased contact with the Justice Department, with the justice system for people of color and poor people. So I also want to note that traffic enforcement doesn't lead to safer roads. And what we need are better road designs and more accessible and equitable public transportation. Another point that I'd like to highlight is that pretextual stops and strategies like this are probably increase the risk of injury to police officers. So with that said, I think strategically limiting equipment and administrative offenses is shown to lower crime rates and accident rates as police have more time and resources to address hazardous driving practices. There's plenty of data that's available through the Connecticut Racial Profiling Project data, spearheaded by the IMRP. But I'd also like to add that House Bill 5324 is a police-friendly bill and is based on the recommendations by the Police Transparency and Accountability Task Force, which includes members of law enforcement and community organizations. Now, ultimately, HB 5324 would make some minor non-safety related traffic stops into secondary offenses, meaning they just cannot be the sole reason to pull someone over. And it actually provides police departments an opportunity to decrease their rates of disparate enforcement on drivers of color. With that said, I highly support this bill, and I hope that we get it out of committee and onto the floor as soon as possible. I'm open for any questions. Thank you.
Thank you, Mr. Goodrich. Good to see you again. Comment, question from members of the committee? Comment, question? Seeing none, thank you for joining us again. Sure, we will see you in the future. Next, we will hear from Keith Dausch.
Thank you very much for having me today. I'm here in support of decriminalizing small amounts of psilocybin and also ask that the committee take the bill further to fully decriminalize. In December of 1995, I was part of the first American troops to enter Bosnia, and when we returned home, I began having problems. When I left the military, those problems grew exponentially. I dealt with depression, anxiety, hypervigilance, and rage. My treatment plan at the VA was medications and cognitive behavioral therapy. After one cycle of CBT, my treatment was medications and meeting with my doctor once every 6 months for 15 minutes. I was not content with the direction my treatment was taking, so I decided to figure things out for myself. I enrolled at Central Connecticut State University and studied anthropology. I studied my mind as its own independent culture in order to learn why I felt the way I did and behaved the way I did. Research shows that entering the military is both an identity and a cultural shift, but there is no shifting either identity or culture when we exit the military. I began working to create a new identity for myself, but quickly learned how hard it can be to undo our belief systems. I started to hear more and more about the research being done with psilocybin, and I started to feel hopeful by the results of these studies. I wanted to try it for myself, and when I did, for the first time in over 25 years, I began to see a noticeable change in who I was. Psilocybin's boost to my neuroplasticity was a major cause for the identity shift that I needed in order to begin living again. The greatest lesson I've learned from this medicine is life is a constant paradox. For example, words are both powerful and meaningless. Our words have the power to shape our lives, but those words need to be filled with the substance of action or they are a waste. I appreciate the sentiment behind people thanking me for my service, but as we're losing 22 veterans a day to suicide, those words ring hollow. Something must be done, and studies show that psilocybin can have a tremendous impact on this fight against veteran suicide. So I ask you on behalf of veterans not to give us your thanks, but to show us instead. I ask you to take the action of crafting a piece of legislation that decriminalizes this medicine and makes it affordable for all communities. I understand this is not for everyone, but from what I've learned and what I've experienced firsthand, I believe this medicine can help save the lives of countless veterans. I was thinking last night how amazing it would be if we can look back through time and watch the effect this medicine has the potential to have. Maybe in one timeline, we see the tragedy of a life cut short, but maybe in the other, thanks to access to this medicine, we see that same veteran happily growing the mushrooms in the privacy and safety of their homes and sharing the joy of this medicine with those they once walked through hell with. Thank you very much.
Thank you. Comment or question from members of the committee? Comment or question? Seeing none, thank you very much for joining us today. We next have Cyrita White. Cyrita White. Okay. How about Duncan Markovich? Good afternoon. When you sit down, press the button to activate your mic and you have your 3 minutes.
Good afternoon, Chairman Safstrom and Winfield, and to the members of the Judiciary Committee. My name is Duncan Markovich, founder and owner of Better Ways, a cannabis therapeutic store in Brantford since 2019. I hold a bachelor's in international relations and an MBA in sustainability, and I also had the privilege speaking at the aforementioned January 10th forum. I'm grateful to have this opportunity to share some general comments and amendments on HB 5297. My father has been a mental health professional for the Department of Psychiatry at Yale for my entire life. So understanding and supporting the dynamics of mental health has been a topic in family ethos for as long as I can remember. So this bill resonates deeply with me from my own recent journey with mental health through the safety of a Fadiman microdosing protocol. My amendments for this bill are as such: removing civil fines, criminal penalties, and identifying record expungement, protecting and supporting home grow rights and acknowledgement to the DEA's recent announcement that spores are legal, and increased awareness and commitment from the Connecticut legislature as a whole to help protect Connecticut from the ongoing aggressive and monopolistic tactics over plant-based medicines by out-of-state corporations, and collaboratively work with native grassroots activists. Similar to my firm views on cannabis, I echo these tenets when it comes to all plant-based medicines. It comes down to purity, preparation, protocol knowledge, professional observation, safe environments, the protection of an existing culture, and above all, the protection of our youth. There's a long-standing community and culture of Indigenous practitioners and licensed medical experts already reincorporating this and other entheogenic protocols back into society, and it would behoove this committee to seek out these resources when weighing options with this bill. I also want to acknowledge the ongoing national psilocybin studies through organizations like MAPS and our very own Yale School of Medicine. To reference Representative Fishbein's comment about our current balancing act with the Supremacy Clause, Article 6, Paragraph 2 of the Constitution, the state of Connecticut has already committed itself to this research at a national level, as well as its commitment to reverse the damage done by opiates and the war on drugs by offering safer alternatives to pharmaceuticals and their side effects. My personal journey with this fantastic fungi is in part due to a lifetime of chronic health issues and my inexorable quest to better my mind, body, and soul. Since birth, I've had 4 open heart surgeries. However, the last watershed in 2010 incurred a catastrophic surgical complication, leaving me bedridden, opiate overwhelmed, and fighting for my life for over 120 days. Cannabis was the first plant-based medicine that helped me detox and separate from all pharmaceuticals, and continues to be a daily regimen. Since 2020, following a strict FATMAN protocol, microdosing psilocybin has allowed me to recover from the PTSD of multiple death and actual near-death experiences, as well as dramatically heal the significant neuropathy issues I've been challenged with since. These psychedelic mushroom strains help to naturally balance our serotonin and dopamine levels, while simultaneously supporting a healthy dendrite life cycle throughout our body's nervous system. Dendrites are responsible for healthy communication between neurons. I attribute my neuropathic healing with this dendrite support, along with findings from Paul Stamets on the neuroregenerative and neuro-anti-inflammatory properties found in the psilocybin analogs. These derivatives help stimulate neuron growth and help activate proteins necessary for stimulating nerve growth factors. When all these compounds are working in unison, their synergistic reaction is far-reaching. I'm hopeful that the conversation held today will help this committee, Connecticut's medical professionals, and our vast network of highly educated, skilled, compassionate healers create a safe and sustainable framework as these plant-based medicines become more and more reintegrated into our society. Thank you for your time.
Thank you. Comment or question from members of the committee. Representative O'Day.
Thank you very much, Mr. Chair. Just real quick, thank you for your testimony, sir. If I missed, I don't think we've heard from any medical professionals. Are you, I know your dad is in the medical profession,
So
correct?
he has a bachelor's in psychology, and he's been a mental health professional as a part of Yale's network for, as I said, my entire life. So working, a lot goes into that. Mainly, a big book of his work was the identification and prevention of psychosis and schizophrenia in youth. And a lot of that had to do with work with street drugs, existing mental health issues, the abuse of street drugs, homelessness, sort of that trifecta of being on the streets, being arrested, being in the inpatient units in the hospitals. So, understanding the dynamics of the mental health industry and world and how that impacts regular people, people with issues, people who develop issues because of life experiences and traumas. These are effective tools that can be safely used with effective medical professionals and those existing in this space already. We're hardwired for plant-based medicines. That's how we evolved physiologically. So going back to, and that's all pharmaceuticals are attempting to do, is chemically reflect what already occurs in nature. So why don't we just stick with nature?
So is he supportive of the psilocybin regimen that you're on currently or taking?
So with the licensed medical professionals in my life, yes, I have found a significant impact from microdosing only. I've had macro dosing experiences, and as mentioned before, and perhaps after, those experiences have many benefits, but they also need to be done in a controlled environment where, somebody like a trip sitter, like somebody who's well experienced with this, and not just academically, like you really have to be a part of it, of that experience, I think, to have an impact, to be well versed in it yourself.
Thank you very much. Thank you, Mr. Chairman.
Thank you.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? Seeing none, thank you very much for joining us this afternoon.
Thank you.
Danielle DeVito. Danielle DeVito. Okay. James Davis. James Davis. I see Sarita White is on. Sarita White.
Hello. Thank you for hosting this event today and having me. I'm here in support of HB 5297. Just a little bit about me. Dare did a great job on me. I'm from Connecticut originally. And when I was a kid, just say no to drugs. But I went to school for psychology. I have a degree in psychology. I am also a Reiki master. I've been a practitioner of Kundalini Maha Yoga for over 20 years. And through this, learning psychology, Maslow's hierarchy of needs, self-actualization, that's been my goal through this. And I've used psychoactive substances to achieve that through time in lots of ceremonial situations. I also have a doctorate in metaphysics. I'm an herbalist, and I'm currently in the School of Evolutionary Herbalism. Mushrooms have been used for thousands of years. It's a sacrament. Like I said, it's used for spiritual use. There's a lot of medical use that it's helpful for depression and all these things, but it's also a tool that many indigenous people have used for thousands of years, to attain self-actualization and connect with different realms in different ways. So I absolutely believe it should be decriminalized. And I think the bill should be amended and there should be no limit. There are psychoactive mushrooms that are currently growing in Connecticut that are legal. Amanita muscaria, many people know as a Mario mushroom, that grows all over Connecticut. It is highly psychoactive, just like psilocybin. And there is no regulation. There is no issue. It's perfectly fine. And it's also been used for thousands of years and has medicinal benefits. So, I don't understand why, but we definitely need to amend that so people can use it to self-regulate. They can also use it to self-medicate and for meditational purposes. That is all. There's different, you can use it for macro, micro, the sitters. There should be a sitter if someone uses it for macro purposes, uses a significant amount. And they use the term trip sitter, but traditionally when people use it outside, it's just someone who just makes sure, it would just be a friend that's sitting beside you to make sure you don't hurt yourself and nothing happens. But at a micro dose, nothing is happening at all. A lot of people use it for a micro dose, and it's just like drinking water. Water is helpful for us. It has all these benefits on a subtle level, and it's just like that. Just having a little microdose of psilocybin has no effect. You can drive, you can go to work, So I'm definitely in support of this bill. I think that psilocybin should be legal, decriminalized, and I think there should be no limits. Just like Amanita muscaria, muscimol. There's so many psychoactive herbs and things that we use on a regular basis. Coffee, chocolates. Someone could go all out and eat significant amount of chocolate and hurt themselves and damage themselves, give themselves diabetes. Same thing with psilocybin. People should be able to regulate things themselves without having the government involved in that. And there should be no fines for having excessive psilocybin or anything like that. Thank you for your time. If you have any questions.
Thank you. Question or comment from members of the committee, Senator Kissel.
Thank you very much, Chairman Winfield. Just a quick question. A lot of times I watch programs called Dead Files, and they have houses that have possessions and stuff like that. And sometimes the woman suggests a Reiki master, and you said you're a Reiki master. So I always wondered, what exactly is a Reiki master? How does one become a Reiki master? If you could just, you said
You become a Reiki master. Anyone could, per se, become a Reiki master through several different attunements. It's someone who channels energy, and you become more aware of energies, and you can manipulate different energies in different ways. In the Bible, I guess they say Jesus had his hands and he was healing with hands and things like that. It is similar. It's a channel. They use Reiki in hospitals now. When I gave birth to my first son, there was a Reiki practitioner right there. It's good for cancer and all sorts of things, balance chakras, bring your body into harmony. And it's energy. Like Doctor of Metaphysics, so everything is energy. Basically, we're all connected. And when people have psilocybin, people are more aware of their connection to each other. I think it should be available to the earth because we're doing a terrible job right now. The earth is dying. All the things that we're doing is just awful, a lot of them. But, psilocybin would give people a different way of thinking. When I went to school for psychology, we learned that Freud most of his theories came after he was ingesting psychoactive medicines like cocaine and all sorts of things. And I thought that was interesting that I'm learning about this guy who's on all these psychoactive medicines and his theories. Why don't I take psychoactive medicines myself and come up with my own theories? So that's what brought me down this path, self-actualization and things.
Yeah, no, I very much appreciate that. I'm probably more of a Jungian than a Freudian, but that's okay. Thank you for your testimony. Thank you, Mr. Chair.
Thank you, Senator. Comment or question from members of the committee? Comment or questions? If not, Ms. Davis, thank you very much for joining us. I'm sorry, I'm looking at the next person. Thank you very much for joining us, Ms. White.
Thank you.
James Davis.
Thank you very much, esteemed committee members. My name is James Davis, and I previously served for the chair of the Joint Committee on Cannabis Policy in Massachusetts and authored and organized thousands of volunteers to pass measures ending arrests for growing mushrooms in 9 New England cities, including 8 in your neighboring Massachusetts. I oppose the psilocybin decriminalization bill 5297 for 3 reasons. First, this bill is going to create confusion across Connecticut for both residents and law enforcement alike. People often read headlines without understanding what decriminalization means, considering that 24 cities nationwide have passed decriminalization measures that allow growing. This bill passed alone without those growing rights would imply to people in Connecticut that they have that right. Unfortunately, they could face up to 15 years in jail, eviction, or custody issues simply because they did not understand the law that would be passed if it's not changed. I urge the Judiciary Committee to look to the example of other states for next legislative session so that these policies on medicines can be reformed in a comprehensive way and to, yes, promote regulated therapeutic use. The second reason we are in opposition is because psilocybin mushrooms, finding them would hurt working families. They're not traffic violations. They grow naturally. They're helping people with depression, addiction to opiates, and even neurological diseases like migraines. So putting fines on this sends the message that access should remain stigmatized and punished. The Fines and Fees Justice Center has found that when fines are put on these types of enforcements, it increases, tickets and fines that are doled out to marginalized people. And third, I wanted to raise the issue that passing this bill alone would create a system of expensive access in the future by undercutting organizing that's happening in New Haven and other cities to slowly educate. In Oregon, the cost of these treatments with psilocybin is $3,500 or more. For members of the public, you deserve to know that there are commercial interests that want psilocybin to remain in a gray area with fines so that people are forced to go into a regulated use model that will break their bank at a time when a lot of residents, both in Connecticut that we work with and in Massachusetts, are struggling to even put food on their tables. For these reasons, we strongly oppose 5297 and urge for it to be changed in next session. Thank you very much.
Thank you. Comment or question from members of the committee? Comment or question? Seeing none, Mr. Davis, thank you very much for joining us today.
Thank you.
Up next, we have Robert Steck.
First, thank you, members of the Judiciary Committee, for this opportunity. I am Robert Steck of Naugatuck, speaking in support of the decriminalization of possession of small amounts of psilocybin. I'm a retired clinical psychologist. I received my PhD in 1978 under Dr. Duncan Blewett, who worked with Hoffer and Osman in investigating LSD in the treatment of severe alcoholism in the 1950s. Dr. Blewett also co-authored the Handbook for the Therapeutic Use of Lysergic Acid Diethylamide 25 Individual and Group Procedures, still in use today. In the early 1960s, Dr. Blewett was among the first to propose that psychedelics should be made available in clinics where individuals could be screened and given the opportunity to benefit from the supervised use of these substances. I was licensed in Connecticut in the 1980s and 90s when I was in private practice, and then a clinical psychologist for the Department of Correction. I also worked for DEMIS for 7 years. In my work privately and for the state of Connecticut, I came in contact with many individuals who abused drugs, but also those who benefited from their use of psychedelics to recover from addiction or resolve other mental health issues. As a result of my training under Dr. Blute, I experienced personally and learned much about psychedelic states of consciousness and the therapeutic use of psychedelics with clients. In my professional capacity, I've had the opportunity to help many individuals who have used psychedelics. I have acted as a trip sitter for individuals who provided their own substances and who wished to benefit from them, either to explore their own consciousness or more specifically to deal with some mental health issues such as anxiety or depression or post-traumatic stress. I've also provided psychedelic integration sessions for individuals who wish to obtain the maximum benefit in understanding their experiences with psilocybin. Research with psychedelics made it apparent that psilocybin can have beneficial mental health effects even for the average individual. Studies consistently find that psilocybin can induce positive psychological experiences effective in treating depression, anxiety, substance abuse disorders, but even enhancing the well-being of healthy individuals. And my own experiences have confirmed this. Psilocybin has been shown to be extremely safe, safer than the use of even alcohol or tobacco, and safe enough to be used responsibly by the average individual, though in my opinion, the best results are often obtained when the psychedelic naive first-time user are supervised by persons trained in their use. The proposed legislation to decriminalize possession of psilocybin is but a first step in eventually improving the lives of the citizens in Connecticut. I urge legislators to carefully research the benefits offered by psilocybin and psychedelic mushrooms. From many experts in the fields that you've heard and from testimony from average citizens, average citizens should not be risking fines or unnecessary imprisonment for their use.
Thank you, Mr. Steck. Comment, question from members of the committee? Representative Porter.
Thank you, Mr. Chair, and thank you, my good friend. You talked about trip sitting, and I just want to know if you could expound on that. I'm very curious to know what a good trip is and what a bad trip is, what you have witnessed in that capacity through you, Mr. Chair.
As a trip sitter, when you're using a large dose, a macro dose, as it's been called here, it can become very confusing, especially for a first-time use. You can become fascinated by the play of light on a plant to the extent that, you get up and you may trip over, a piece of furniture that's in your way because you're so fascinated. You may be very, very thirsty, and if there's no one there to help, you may become confused. Where do I find glasses? Do I want hot water or cold water? I mean, silly things like that come to mind when you're under the influence of these things. Among many psychedelic users, and especially those in therapy, there's no such thing as a bad trip. A bad trip may be emotionally draining. In the times that I have been a trip sitter, I have only come across one instance where I've been the trip sitter where the individual spent 3-4 hours of that time just crying and feeling terrible and revisiting the trauma. Yet after they recovered from that session, I received a gift from that individual of a handmade quilt, just to thank me for having been there for her. So sometimes the most emotionally draining sessions people might consider a bad trip, but they're also those sessions where you get the most out of it. A good session, essentially people feel like they're reborn again. Many people have a very spiritual or religious experience. That's why they're sometimes called entheogens. They bring out our connection to the spiritual. What's interesting is that there's almost no way to predict what a person will experience, especially the first time or two that they may use these things.
Thank you for that. And can you just
Just one thing, Representative Porter, just not to cut you off, but I don't want to be accused of not being fair. I have cautioned folks on both sides of the aisle about going too deep into the individual experience and not dealing with the legalization aspect. You may continue, but I do not want someone to say I've treated anyone differently.
And I appreciate you making that point. And I would never accuse you of that.
I wasn't worried about you.
Okay. I'm like, yeah, you don't have to worry about that. First, I wanted to, second, how long have you been doing this work around being, this is intimate contact that you have with people that are experiencing it. And before you answer that, I'll just say in response that, to what the good chair said, I think it's important that we hear about the experiences, because we have people here that are testifying with that lived experience and it's coming through their lens. But I'm always interested in knowing what the lens on the opposite side of that experience looks like. And I haven't had it, you have. So that was the reason why I wanted to hear from your perspective what that experience looks like. But back to the question, how long have you been doing this work?
Well, technically, I guess it started in graduate school with other graduate students and faculty of the university. Although I have not been a psychedelic therapist per se, which I define as someone who is following an established protocol in the use of any type of psychedelics. I have been doing this for the last 10, 12 years or so since I've retired. And not a lot. I'm not trying to say I do this, every day or every week or even every month.
Okay. Well, thank you so much for your testimony today. I appreciate you coming in. Thank you, Mr. Chair.
Thank you, Representative. Representative Howard, followed by Senator Kissel.
Thank you, Mr. Chairman. Dr. Steck, correct?
Yes.
Thank
Yes.
you, sir, for being here. I have a question for you that, when your experience, how this impacts an individual's ability to drive. We heard, and I think you've been here most of the day, we heard somebody testify earlier that certainly the macro doses would impair their ability to drive, but that micro doses may not. I didn't know if you had experience or an opinion on that.
Yes, microdoses, almost by definition, if you're taking, someone gives you what they call a microdose and you feel different, it's too much. That is, a microdose should not, give you any effect of, staring at butterflies or, feeling that you're in touch with, a greater reality. A microdose is something that you only notice the effects over time. If you notice it while you're taking it, it's not a microdose. So the ability to drive, if you're taking a true microdose, and it wouldn't have any effect.
You know what other states who have either, and to be clear, this bill doesn't legalize it, it decriminalizes it, but as you said, it's a step towards it. This is the similar path that we took with cannabis in this state beginning, I think, somewhere around 2013-ish. So the other states that have legalized it, let's just say, or decriminalized it, whichever one, how are they dealing with that as far as recognition and enforcement of impaired driving when it does have an effect?
I am not sure. I just can't answer you. I'm sorry.
Okay. So like for alcohol, for example, right? We have police officers who are trained to identify somebody who's impaired. They use standardized field sobriety tests. They're tests that are standard to a scientific standard. That's where that comes from. Then we have prima facie evidence of 0.08. That's our statute about. We legalize marijuana, and we don't, you heard earlier testimony, we don't have the drug recognition experts now. I don't want to represent that this is the problem, but it may be a contributing problem that since we legalize marijuana, we have massive fatalities on our highways. That is my concern. So do you know do you have any idea of how drug recognition experts or the physiological effects that would be identifiable when somebody is taking too much of it?
If they're taking too much of it, they would probably self-regulate and say, there's no way that I'm capable of driving a car. Maybe there is an amount between microdosing and a massive dose, a small amount that would make people. I really don't know.
I just want to understand what you said. So your testimony is that if somebody takes too much, they would recognize it and not drive?
That's more likely, in my
Okay.
opinion, that they would say, I'm too uncoordinated. Now, for someone who has been abusing drugs, someone who have just discovered psilocybin and is taking it frequently and getting used to it and trying to go to clubs and music events and whatnot, that may happen. Yet at the same time, I know that my mentor, Dr. Blewett, I've seen him give the same lecture that he has always given in psychology classes under the influence of LSD. And for him and his experience, it made no difference as far as his outward behavior was concerned. But he was also, a very different individual. There can be people who will take too much and try to drive. I would think that some of the indicators of, actually, I think one indicator would be if they would laugh. If they would laugh a lot at being pulled over and, have that kind of attitude from Alice in Wonderland, oh, you're nothing but a pack of cards. And, just not realize the seriousness of their situation might be an indicator, for example. But as far as any kind of test of, blowing into some apparatus, I don't think that exists.
Okay. Thank you for your input and your expertise. I appreciate it. Thank you, Mr. Chairman.
Thank you. Comment or questions from members of the committee? Comment or questions from members of the committee? Seeing none, thank you very much for joining us this afternoon.
Thank you.
Mr.
Chairman,
Yes.
question.
Yes, there is a question for you. Representative Dubinsky.
Thank you, Mr. Chairman. Sorry, I was kind of hiding behind the Zoom wall. Thank you, Doctor, for coming in. I had a couple of quick questions for you. Is psilocybin, is it something that a doctor can prescribe right now?
No, not now, no.
Is that state law or is that federal law?
That's federal.
Okay, so it's on a schedule that prohibits
Right.
doctor from prescribing it?
It was in the war on drugs. It was made a Schedule 1 drug, meaning it had absolutely no use whatsoever. And I think we've been finding out that it has a lot of good uses.
Right. Well, I'm going to assume for purposes of today that you're right and that psilocybin has some medicinal uses, whether for depression or some other type of mental condition. I have read quite a bit about it, and my understanding is that it may well have some medicinal benefits. If that's true, how does this bill help us with the issue of having of addressing the medical need for some patients to have it? Like how does this bill help the situation that it's illegal under federal law?
It becomes, I think, as was referenced earlier, which has the primacy, the federal law or, state law. And that's something that will be, decided by the court system. Someone at some point will say, all right, we've got to straighten this out. and there will be, cases, and it will be decided. But this bill is just one small step for people in the state of Connecticut who potentially, could face fines that they can't afford, and even prison sentences for the use of a small amount of a substance that can help them with their anxiety, depression, whatever, and the research has just shown, it's good medicine, and it's possible to self-medicate with it, just as people self-medicate with chamomile tea, with aspirin, with other substances that have medicinal effects.
Okay, so is it your anticipation that people will do so under consultation of a medical professional of some sort?
I would like to see that eventually, and it doesn't even necessarily be a medical professional, a mental health professional, someone trained specifically, for the task could also be helpful. But again, there's such a wide use for psilocybin and some of these other substances that, depending upon the mindset of the individuals, the setting in which it's given, and the dosage, it could be something that requires someone very highly trained, or it could be something that requires only someone, to be there and to be the trip sitter that provides the safety in the environment, which could be just a friend, or someone who may have had a session or two themselves.
And trained in what?
In the effects and the use, what people can expect in people who take, psilocybin, can have very diverse experiences, from feeling like they're, connected to ancestors that go back generations. People can feel that they're in touch with beings in another dimension, and people can just enjoy the beauty of nature and be fascinated by a butterfly flitting about, or a flower on a plant. They can go deeper into their own emotions and feel a real connectedness with others in their family or those around them, a feeling of brotherhood, of connection. There's a wide variety of effects that have been reported with these things, and someone who is trained can be very helpful in helping the person get the most benefit out of these things.
Who would do the training?
I think some of the researchers who have been doing this work for many years are setting up training programs. I know MAPS, the Multidisciplinary Association for Psychedelic Studies, has been training people for the use of MDMA in treating PTSD for over 10 years. Is
that a Connecticut organization?
No, it isn't. This is a national organization that was started back in the late 1980s and has been shepherding right up now to the more current trials with the FDA for the legalization of MDMA.
Okay. With regard to, you mentioned a bunch of different types of experience that different people have. Is that typically dosage dependent?
Just before you answer, I'll let you answer this question. I've said this several times today. I have cautioned folks on both sides of the aisle about getting too much into the individual experience. We've had some of that conversation today. We're trying to stick to the issue of legalization, not the individual experiences. You may proceed with your answer.
Well, Mr. Chairman, just to give you an idea where I'm going with this, the bill talks about how that we're decriminalizing possession of less than half an ounce. So I'm trying to find out if that's the appropriate amount. It's right in the bill about the dosage. So
Right.
that's
20
what.
28 grams equals 1 ounce.
Yeah,
And-
I just will say that, again, one, I've allowed a lot of leeway on this. I recognize you weren't necessarily there to hear it. I don't want us going into too deep into the individual experience. If you are
Understood.
I will let you respond. I always do. I think you know that. And I think that we have had a conversation about microdosing versus macrodosing on that very topic. And there is general agreement about kind of where we are, but no one's going to give you the exact number on that, I don't think. There's a kind of shared experience on that, but that's why I think going too deep into that is not where we want to go. You may respond.
Again, if there are, 28 grams in an ounce and a macro dose is, say, 3 to 5 or 6 grams, and the micro dose would be less than a very small amount, a portion of a gram. So that seems to be a reasonable amount, in my opinion.
Okay, now we have when we had these discussions with regard to marijuana, we had a lot of testimony about people telling us that today's marijuana is a lot different and a lot stronger than the breeds of the past. Is that the same with the mushrooms? Have they changed over time? Or are they much more powerful than they've been?
One study that I'm aware of that looked at the potency of different varieties of psychedelic mushrooms pegged their potency as a percent of weight from about 0.6% to 1% for the most potent mushrooms. And I've never seen anyone talk about creating more potent mushrooms or there be any change in the potency over many years.
Okay, so they're pretty much the same ones from 30, 40 years ago.
Yes, I would say so.
All right, great. Well, thank you very much. I appreciate your testimony. Thank you, Mr. Chairman.
Thank you, Representative. Comment, question from other members of the committee, comment, question from other members of the committee. Seeing none, thank you very much for joining us today. Chief State's Attorney, Patrick Griffin. Good afternoon. You may begin your testimony once you click the red button.
Good afternoon. Senator Winfield, Representative Staffstrom, Senator Kissel's here, but distinguished members of the Judiciary Committee, I'm Chief State's Attorney Patrick Griffin, and I'm here on behalf of the Division of Criminal Justice to support HB number 5055, which is an act strengthening police data reporting requirements. At its core, the bill is intended to enhance public confidence in our state and local law enforcement officials and their performance of their duties by codifying what I would describe as the minimum expectations that professionals in policing demands. The truth and veracity of our law enforcement officials and the accurate recording of information forms the very foundation of our criminal justice system. I have often publicly stated that the job of the modern officer is an extremely difficult one. As a society, we demand much from the officer. We tell our officers that they must be a defender of the community in the war against violence, a social worker capable of compassionately dealing with the impoverished and the alienated, and a constitutional scholar who must know and understand and apply the decisions in the Supreme Court in real time and under incredible stress. Having said that, Section 1 of the proposed bill creating the new crime of false statement in a law enforcement record does not impose new obligations on our Connecticut law enforcement officers. Rather, it makes explicit that which is already well known and understood by law enforcement professionals, that a police officer cannot, in the performance of his or her official duties, knowingly and intentionally make a false statement whether it's written or enter false information or data in a law enforcement record for the purpose of misleading a public servant in the performance of his or her duties. The proposal rightly places a high burden on the state. It is not intended to, and in my opinion, does not capture the inadvertent, the accidental, or good faith mistakes. Such acts, though regrettable, are not criminal, and prosecution is not warranted. The language is intended to mislead a public servant in the performance of such public servant's official function constitutes, in my opinion, a critical component of the proposed bill, as it provides an intent element that distinguishes the officer's conduct or actions in circumstances which this bill seeks to criminalize from ordinary acts inherent in the job of an investigator. For example, an officer may be called to take a statement that we might characterize an alibi statement, and that the officer subjectively does not believe. That would not be a false statement. That would be memorializing the statement. There would be no intent to deceive a public official. The proposed statute in defining a law enforcement record recognizes that the collection of data in an electronic age is no longer confined to written reports, and it properly defines a law enforcement record to include all information collected or maintained in connection with the detection or investigation of crimes or motor vehicle violations by a law enforcement unit that is inscribed on a tangible medium or that is stored in electronic or other medium and is retrievable in perceivable form. As to Section 2, it's the division's position is that false statement is included. We would ask that that be considered as a standalone crime. I would ask that the committee does ask me questions related to subsection
We have
3.
questions for you.
Okay.
Chair Stafford.
Thank you, Mr. Chair and Chief State's Attorney Griffin. Always good to see you. Appreciate your time. So a couple quick questions for you. I don't know how much of the dialogue you've been following from earlier today when I discussed this with the Commissioner of Public Safety, but there's a proposal in line 3 to strike the words "as a police officer" and essentially expand this bill to include those who are working in law enforcement who are not sworn police officers as well. Seems to make some sense to me, and wondering if you have any thoughts on that.
Yes, thank you for the question. So in the last 48 hours or so, my folks at the Chief State's Attorney's Office and I have been discussing whether the proposal in the governor's bill was too narrow. And so the proposed language that, as I understand it, as you've just articulated to me, actually would strengthen the bill. It does not weaken it. And so I would support that.
Okay, great. And then on Section 3, I know you had some proposed language changes you wanted us to entertain. So if you could just take us through that real quick.
Sure. We are in support of the proposed bill's addition of language to subsection H1 of Section 294D of the General Statutes, which provides for automatic referral to the police officer standing in training council of matters to reflect upon the truthfulness of the certificate holder. We would suggest, however, that the language in proposed subsection E2 should read as follows: knowingly making a false statement with the intent to deceive during a criminal, civil, or administrative proceedings. And then as to subsection 3 itself, the division maintains that as currently drafted, subsection 3 is overly broad, and we would recommend the following language: the chief law enforcement officer of each law enforcement unit shall promptly notify the appropriate state's attorney of any matter in which such chief law enforcement officer reasonably suspects that a certificate holder has engaged in conduct that constitutes a violation of any criminal law of the state. Simply put, the primary objective of this reporting requirement should be to alert the local state's attorney at the earliest possible time to the potential that an internal investigation may lead to criminal charges. In my opinion, prompt notification is critical to the state's attorney's evaluation first, and I did not include this, and it was an error on my part, regarding Giglio, right? We may have an officer who's under investigation for an incident that potentially is criminal, but goes to truth and veracity, and a state's attorney or a prosecutor may be calling that person to the stand. We need to know that. Second, I think it's critical for the state's attorney to be able to analyze any applicable statute of limitation issues that might rise. So if we're talking about misdemeanors and an internal affairs investigation may last longer, than a year. We should know about that and be able to weigh in. And also, the state's attorneys are often called upon. In fact, when you're dealing with a police officer who's under criminal investigation from the jurisdiction in which they work, there has to be a conflict resolution, meaning that the state's attorney has got to make a determination with the input of the chief state's attorney as to whether or not the local police department can handle the investigation, and or second, whether there needs to be a new state's attorney to come in if there's criminal investigation.
So I think I'm following you at least on the first half of this. So the first concern is if you've got an officer under investigation, you want the local state's attorney to know so they don't put that officer on the stand essentially, and they're going to be readily impeached and blow up an unrelated investigation, right? That I'm with you on notifying. I guess on the second piece in terms of the potential for conflict and who should do that investigation. A couple years ago, we created this amazing new office called the Office of the Inspector General. I mean, it would seem to me, though, that the investigation shouldn't be handled by the local state's attorney, no different than how we moved out use of force investigations, and that should then be handled by the Inspector General's office, no?
Well, I would disagree that the Inspector General should essentially become the IA of the entire state. What the normal procedure for us is, what really Section 3 does is, in my opinion, would codify the very best practices that are followed currently in the state. I was a state's attorney for 6 years in New Haven. If we had an internal affairs investigation that potentially led to criminal charges, I was notified. And if it looked like it was going to go criminal, the determination often was made to go outside my JD, notify the chief state's attorney, and get a state's attorney from another JD in. We do this routinely. So the conflict review is something that I think is important.
I think maybe we're talking past each other. I'm not talking about making the Inspector General sort of do IA around the state. I guess what I'm saying is at that point in time where somebody has determined, you know what, there probably is criminal conduct here that needs to be prosecuted. It would seem to me like that's the point at which, instead of referring it from, say, the New Haven GA to the Bridgeport GA, that it gets referred to the Inspector General at that point.
Well, you'd have to expand his authority. He doesn't have authority to.
Well, that's what I'm saying. I think the language should expand the authority.
I would caution on that. The number of police officer involved shootings in the state, unfortunately, is very significant. The workload of the Inspector General is heavy. It is my understanding, and I'll stand corrected, but the impetus of creation of that unit was in reflection of the community's concern that these crucial investigations involving officer use of force were better handled by an independent body. I don't think that it's necessary to burden the Inspector General with every conflict resolution type case in the state. As the chief state's attorney, I feel that I'm capable of doing that. I think that we routinely handle conflicts and we move them between jurisdictions.
Okay. No, and I can appreciate that. I mean, it's why I asked the question. I was genuinely curious sort of about workload and whether it was feasible or not. I mean, I guess in an ideal world, it would be something like the Office of the Inspector General that would do it. But if you're telling me that they don't have the capacity to take this on, then I think that's something we need to take into account.
I would caution against that at this time.
Okay. No, I mean, because it is a concern. I mean, we saw, the number of not just police shootings, but misconduct instances. I mean, we had 10 police officers decertified last year. We have another 30 who are up for decertification currently.
And not to be flippant, right? That's what you want the Inspector General to handle, not whether or not an individual, say, has picked up a domestic that could be handled by another state's attorney who has no connection to the local police department, to the local officer, that is duty bound and honor bound to handle that investigation and prosecution properly.
No, understood. Appreciate it. Thank you.
Thank you. Representative Howard.
Thank you, Mr. Chairman. Thank you, Chief, for being here. You said a couple of times that your office routinely will have another JD investigate officers. So When that routinely happens, is it your experience that those officers are active duty during that investigation? Or are they on some sort of administrative leave or desk duty?
Yeah, well, let me make it clear so that I didn't misspeak. It's not uncommon, right, unfortunately, for a police officer across the state to pick up criminal charges. And when that occurs, the local state's attorney is notified. And then in conjunction with myself as the chief, we make a determination as to whether or not the local state's attorney can handle the investigation. More often than not, to avoid the appearance of impropriety or the appearance of a conflict, we will refer that to another state's attorney. It's a mixed bag. I would say, if you're asking me to quantify it, I would say that we unfortunately have had a number of cases in which officers have been accused of misconduct while on duty, and we've had certainly in many cases in which it was off duty.
All right, let me clarify my question. When you get notified that a police officer needs to be investigated or may be guilty of a crime, and you're either the state's attorney, one of your state's attorneys, say in a different county or a different JD,
Yep.
does the investigation.
Wouldn't do the investigation for the crime necessarily, right? So the local police department, it depends on the stage of the investigation. As you know, a crime may have already been committed,
right,
and doesn't require a lengthy investigation, and therefore it's simply a notification issue.
Okay, so when a police officer is being investigated for a crime, and your vast experience, because you were state's attorney before you were chief state's attorney, are those officers working during that investigation, or are they on some sort of leave?
Oh, I'm sorry, I misunderstood you. Generally speaking, they would be placed on administrative leave. That's at the discretion generally of the chief law enforcement officer of the head of the department, the chief.
Okay, and this is a loaded question, and I understand that there's probably a range based on circumstances. But in general, when a police officer is suspected of a crime and an investigation is taking place, how long does that investigation take?
That's a loaded question.
Yeah, I know it's unfair, but can you say a range?
No, because if you said to me, if I'm notified that there's a suspicion that Officer X drove intoxicated, and we're in the police department or the state police is waiting for toxicology, that may take 10 days, and all that's required is an up or down determination, then that's a quick turnaround. If it's a domestic matter in which the police have already made an on-site arrest, that's a quick determination. If it is a question of misfeasance or malfeasance, suggesting in a situation where an officer is engaged in this unlawful conduct during the course of a long period of time, clearly that may take longer period.
The language as drafted, and are we in agreement that when a police officer is on that administrative leave, he or she is unable to work any overtime? That's your experience, right? When they're on administrative leave, they can't work overtime?
I believe that's true.
Okay. And the drafted language, and I understand that you're suggesting a change, but the drafted language says for any alleged, a certificate holder has alleged to engage in conduct that constitutes a violation of any criminal law. You said that was too broad. Does that mean that do you have concern that allegations that are immediately unfounded would get caught up and referred to your office, and it would overburden you and keep too many officers off the road?
Yeah, I mean, there's a lot of concerns that I have, and the representative from the Connecticut Chiefs Police Association, I thought, did an excellent job in articulating it from the police standpoint. From my standpoint, as the chief state's attorney, I don't need to know if an officer has been accused of speeding or had a motor vehicle accident. What I need to know, and the state's attorneys need to know, number one is there a situation that we need to know about that goes to truth and veracity that might impact our ability to put that officer on the stand, one, or could compromise an ongoing investigation or prosecution, two. Then as I went into the other aspects of it, what we learned during the course of the state police investigation, for example, is in 2018, there was no referral to the local state's attorneys for review. And as a result of that, without going into great detail, statute of limitations were lost. And I think that
Right.
the local state's attorney should weigh in on that.
And so your suggested amended language would make it much more narrow. And to use the chairman's word, when somebody in the police department, which I assume would be a ranking officer, somebody in IA or something like that, looks at this and says, there may be a crime, which police officers are trained to do. They generally do that. If there may be, they would notify you or somebody, a state's attorney, who would look at it and say, okay, yeah, it does look like there's a crime and maybe we should do more. So they're involved in the conversation going forward.
Yeah, essentially what this does is codify, if you will, the conversation that in my mind should always occur, which is that there should be communication between the state's attorney and the local JD and the chief of whatever department, right? And so, for example, you might have a situation where there's an allegation that a police officer is sleeping behind a building. Well, that's not gonna, that may impact the police world. It's not gonna impact mine. But then during the course of the investigation, it's determined he's sleeping behind a building and his car is full of stolen goods. And that only comes out, right, if you will, midway through the IA investigation. So I should be notified, or I say I'm no longer the state's attorney in New Haven, but if I was, I'd want to be notified of that, so that we could make appropriate determinations.
So as I understand your suggested language, and it seems I agree with it, because what I gather from you is, listen, I don't need my state's attorneys investigating every single time somebody says they don't like something a police officer did. But when within the department they say, hey, this is a problem, there's a problem brewing, I want my state's attorney in my office brought in right away so we can work collaboratively to resolve the issue. Is that fair?
It's a fair point, and if I could just put a finer point on it, I believe that language codifies
current practice.
Best practice.
Best practice, better. Oh, sorry.
Yeah, I think that's what should be going on.
The practice that you would expect from your police departments.
It's the practice that I would hope is ongoing, but if it's not, it should be in law. I do believe that.
My last question, constitutes a violation of any criminal law of this state. So obviously it's against the law to drive without your seatbelt on. Clearly you don't want those. How do you differentiate a criminal law from other laws?
Well, this body has done that, as I understand it. 53A24 defines a crime as all felonies and misdemeanors. So in Connecticut, you have felonies, misdemeanors, violations, and infractions.
Okay.
Clearly, and again, if I might, just a fine point, this recommendation, right, it comes in part from the daily report. And in the daily report, it was suggested that serious violations be referred to the state's attorney. The problem with that is that's subjective, right?
Yeah.
And you're going to put a chief in a tough position to determine what's serious. So I'm saying to this body, just make it a crime. Crime's defined as anything that a person be put in jail for. Some of them are going to be quick and some of them are going to be longer, to your point earlier. And I can't do better than that, sir, on that.
No, that makes perfect sense. So you're essentially saying, generally speaking, and we could probably sift through the volumes of criminal laws that we have in the state of Connecticut and find some anomaly, but generally speaking, what you're asking is when a police department knows that one of its officers is involved or suspected of committing a misdemeanor or felony offense, the state's attorney needs to be made aware of that. Is that fair?
Yes, sir.
All right. Thank you. Thank you, Mr. Chairman.
Thank you. Comment or question from other members of the committee? Representative Quinn.
Thank you, Mr. Chairman, and good to see you again, Chief.
Thank you, sir.
Switching gears, your office taking any position on 5297, the psilocybin legalization? I mean, and before you answer that, is it much of a problem that your prosecutors are seeing people being charged with this?
For small amounts of
Yeah.
mushrooms? No, I listen, this is anecdotal, guys, but I've been a prosecutor for close to 30 years. I don't believe I've ever charged it. If it is charged, there's a host of programs. So here's what I would say, with all due respect. We're not going to prosecute our way out of this issue, and it's outside my lane, right? I don't know the beneficial therapeutic aspects of this. I would think the FDAA would weigh in on that, but it's with all due respect, sir, it's sort of out of my lane.
Okay. All right. Thank you.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us again.
Appreciate it. Thank you.
Next, it will be Jess Zacagnino. Good afternoon.
Good afternoon. Senator Winfield, Representative Staffstrom, Ranking Members Kissel and Fishbein, and distinguished members of the Judiciary Committee. My name is Jess Zaccanino, and I'm the Policy Counsel of the American Civil Liberties Union of Connecticut. I'm here to testify in support of House Bill 5324, an act establishing secondary traffic violations. House Bill 5324 would designate a small number of low-level, low-risk traffic violations as secondary violations and would prohibit police from stopping cars for these violations. The secondary violations identified in this bill make up a small sliver of about 700 potential traffic violations, and there's strong evidence from years of Connecticut crash data that stops for secondary violations do not reduce accidents. Secondary traffic violations will allow police to shift enforcement priorities to focus on safety-related enforcement while shrinking racial disparities in policing. In 2022, the Connecticut Racial Profiling Project analyzed 5 years of crash data and found that the secondary violations proposed by this bill do not contribute to motor vehicle crashes. For example, tinted windows accounted for 4,378 traffic stops, but only contributed to 0.1% of crashes. Similarly, a single broken headlight, taillight, brake light accounted for 24,000 stops, but contributed to, again, 0.1% of crashes. License plate display violations similarly accounted for over 14,000 stops, but did not appear to have a significant contribution to crashes. And many of the administrative violations named in this bill, like an expired registration, could not be traced to accidents. We do know that traffic stops result in many more searches of drivers of color relative to white drivers, even though that searches of drivers of color are much less likely to find criminal activity or contraband. And Black drivers are overrepresented in both stops that do not escalate to enforcement, as well as the ones that do end in arrest. House Bill 5324 addresses only about 16 out of the approximately 700 motor vehicle violations listed in Connecticut's infraction booklet. Of those 16 violations, only 7 would become truly secondary, 3 are clarifications of law, and 5 are already de facto statutes, meaningfully removing merely 7 of the 700 possible motor vehicle violations. The ones that do not have a statistically significant connection to traffic accidents or fatalities will not result in less enforcement or an increase in accidents. But rather, secondary violations will allow police to redirect their limited time dedicated to traffic enforcement to focus on safety-related enforcement, like speeding or distracted driving. Last year, this bill passed out of committee and also passed out of Senate with a bipartisan vote. The ACLU of Connecticut supports House Bill 5324 and encourages this committee to do the same. Thank you.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? If not, thank you for joining us today.
Thank you.
Minority Leader Vincent Candelora. Okay. We will hear from Chelsea Moore next. Ms. Moore, if you're there, you're muted. We can't hear you.
Hello?
There we go.
Okay. Okay, so my name is Chelsea Moore, and I'm not in support of the bill 5297 as it is currently written. My background and training is in the worlds of transformation and trauma, which I would like to point out are distinct from psychiatry. I'm here to speak on the responsible use and growth of psilocybin mushrooms as a matter of dignity. While the clinical studies of psychedelic substances for use of treatment of mental health disorders is exciting, taking strides where pharmaceuticals and current psychological treatments have historically failed, I'm here to talk about the rest of us. Not diagnosed or deemed broken, but the everyday person dealing with everyday struggles and stresses of life. I'm talking about early intervention prevention. I quote Matchbox 20. I'm not crazy. I'm just a little unwell. I know right now you can't tell, but stay a while and maybe then you'll see a different side of me. I'm not crazy. I'm just a little impaired. I know right now you don't care, but soon enough you're going to think of me and how I used to be. There is a distinction between healing wounds and transformation and treating mental illness. The Department of Health and Human Services has declared that America has a loneliness epidemic. Quote, in fact, loneliness and isolation increases the risk for individuals to develop mental health challenges in their lives. There is an opinion that this is the effect of a crisis of consciousness. which work with psilocybin mushrooms, elevates. I missed the gentleman's name that shared earlier about making the use normal. Yes, I would like to make the conversation for healing trauma normal, destigmatized, that everyone deals with wounds. As a person that has sat for friends and family, I like to call myself a guide. Distinct from being a highly trained mental health professional, I tend to the physical form as people take their trip. But that's the distinction. The people are doing the work. I could encourage people to engage, but it is up to them. And it doesn't mean that there aren't people that also need higher levels of supervision and treatment. Putting this matter into the clinical pharmacological world takes the potential this powerful agent for transformation has out of the hands of everyday people. In my opinion, this lacks dignity. Additionally, I believe that a half an ounce is insufficient, and I recommend a full ounce of decriminalization. Thank you.
Thank you. Comments or questions from members of the committee? Comments or questions from members of the committee? Representative Porter.
Thank you, Mr. Chair. Just one question. I'm very curious to know what's leading you to say that a half an ounce is not enough and that it should be 1 ounce? Through you, Mr. Chair.
Ms. Moore, did you? Oh, okay.
Yeah, it is also in how it gets distributed and used. So as has stated before, each person will see that what that amount is or is not, how they use it personally, what it is, the amounts that they're going to use. But it could be that the method that you are using that goes through very quickly, and you need to find yourself going to get more in a manner that is often and highly inconvenient.
Thank you for that response, and thank you, Mr. Chair.
Thank you. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us today. Marcus Palumbo.
Good afternoon, honorable members of the Judiciary Committee. My name is Marcus Palumbo. I'm a resident of Mansfield, and I'm here testifying in support of HB 55, an act strengthening police data reporting requirements. So there's a common expression, a lot of political leaders, from different sides of the aisle, both Barack Obama and George H.W. Bush have referenced it, which is that no one should be above the law. And I mean, it's a simple idea, right? That the law ought to apply equally to the same actions, no matter who you are in life. And yet we have here before us today an instance where there are people who are above the law as the law is written, and that they are being allowed an opportunity to do something that others, because of their position, are not allowed to do. Currently, it's illegal for you or me to falsify information on a police report and tell an officer something that we know is not true. However, that same exact action is perfectly legal for a police officer to do. I mean, think about how problematic that is. Like, if I lie to an officer at a traffic stop, that could get me in serious trouble. But if an officer lied about me at a traffic stop, right now, there's nothing wrong with that. They could lie about what I was doing, or maybe even whether I existed at all. And that is what happened last year with what came out about traffic tickets. Now, while this is an important first step, as others have alluded to, there are other things that need to be done as well. For example, the report on the ticketing scandal did claim that most of the inaccuracies were accidental and not intentional. And if that's true, then that means that this bill doesn't really address that, in the sense that it only penalizes intentional, that is to say, knowing falsification. So more needs to be done to ensure that there aren't these mistakes, and to ensure that officers don't, falsify information and then pass it off as being a mistake. But that doesn't mean that this bill is bad, and we obviously and absolutely should still make it just as equally a crime for an officer to put false information knowingly on a report as it was for someone like me. Ultimately, at the end of the day, I want to live in a state where no one is above the law. So thank you.
Thank you. Questions or comments from the committee? Questions or comments? Seeing none. Thanks for being with us.
Thank you.
Ken Barone?
Good afternoon, members of the Judiciary Committee. My name is Ken Barone. I'm the Associate Director of the Institute for Municipal and Regional Policy at the University of Connecticut. Since 2012, I've managed Connecticut's Racial Profiling Prohibition Project and other statewide policing initiatives. Today, I am not speaking on behalf of the Connecticut Racial Profiling Prohibition Project, but rather in my capacity as the researcher who worked for the Connecticut Police Transparency and Accountability Task Force. This task force was created by the General Assembly in 2019, concluded their work in 2021. The task force consisted of 10 voting members, 6 of whom were current or former law enforcement, and 4 community stakeholders. The reforms outlined in House Bill 5324, an act concerning secondary stops, were developed by this task force, and they were unanimously endorsed by the task force. Many points have already been made today about this bill. There's a few data highlights that I'd like to just highlight myself or reiterate. Again, I think it's important to remember that the Motor Vehicle Code includes almost 700 reasons to stop a car. It is virtually impossible for anybody to get behind the wheel of their car and not have some technical violation that they are committing based on the way our statutes are written. This bill deals with 16 of those violations, 3 of which are just technical fixes in law. 5 of the violations outlined in the statute, I would argue, are already secondary in nature. And so the bill really only deals with 8 violations being made secondary. Of those 8, 2 of them we have no evidence that drivers are actually stopped for. So in my opinion, we're really talking about 6 reforms out of close to 700, which is less than 1% of the Motor Vehicle Code. The violations that the task force specifically targeted when they put this proposal together would not have an impact on traffic crashes. They were listed as a contributing factor in crashes, less than 0.1% of all crashes. Lastly, in 2023, and I think this is important, there were 5,483 police officers that reported making a traffic stop in the state of Connecticut. That averages to 59 stops in 2023, or less than 1.5 stops the average officer is making every week. So we understand and we know that police have limited time and limited resources for police enforcement. That is clear by these numbers. And what I hope this bill will end up doing is helping law enforcement to focus their time, attention, and resources on those violations that we know are killing people: speeding, distracted driving, running stop signs, running red lights, following too closely, and failure to maintain the proper lane. Thank you.
Thank you, Ken. Questions or comments? Representative Howard.
Thank you, Ken. Thanks for being here. You know, you and I have discussed this at length, and I don't have so many questions for you, but I think I do want to ask you one. So in an earlier testimony, we talked about investigative stops or reasonable articulable suspicion stops, right? So, I mean, every stop is reasonable suspicion, right? It may be reasonable suspicion they were speeding or whatever. What we heard was that a reasonable suspicion stop would include speeders. Yet the training that you give to law enforcement officers says exactly the opposite of that. It has an investigation, a violation, and an equipment. So when an officer stops somebody for speeding in this state, is that a violation stop or is that an investigative stop?
It should be listed as assuming that that's the reason why they're stopping them. Even if they have other reasons, it would be listed as a motor vehicle violation, not as an investigative stop. An investigative stop, the intent of that, say, data collection field is 6'4" white male driving red car, just robbed a bank a mile away, and I'm out there stopping cars looking for a bank robber. That's an investigative stop.
Correct.
In my mind, yes.
So when we heard earlier that those investigative stops would include the speeders, that's not necessarily accurate in the way that we collect data.
Again, if the primary reason for stopping the vehicle is speeding, even if it's being used as a pretext, let's say, that still should be coded as a motor vehicle violation, not an investigative stop.
Correct. Thank you.
Further questions or comments? Representative Porter.
Thank you, Mr. Chair, and good to see you, Ken. One question, and I'm asking this based on things that were said earlier. Can you tell me what traffic stops, what that data looks like for 2023?
So traffic enforcement in the state of Connecticut in 2023 has increased approximately 15% compared to 2022. There were about 360,000 traffic stops statewide in 2023. Municipal police departments, there's 95 of them, collectively made 49,000 more traffic stops in 2023 than they did in 2022. The state police made 7,000 fewer traffic stops, preliminary data tells us, than they did in 2023, but they're still up. 2019, there were 512,000 traffic stops. 2020, that number was cut almost in half, 247,000 traffic stops. It really didn't increase all that much in 2021. We saw a fairly sizable increase between 21 and 22 because state police went from making 74,000 traffic stops to 110,000. And in 2023, it's clear that municipal departments have been focused on increased enforcement. We're still down about 28% from where we were before the pandemic, but we are certainly headed in the right direction, and we're up about 120,000 stops from our low in 2020.
Thank you. And one last question. Can you speak to what the increase looks like, right? What were those increase in stops for?
Yeah, so good news is that we reported in November that for the third year in the row in Connecticut, we did not identify any statistically significant racial and ethnic disparities in statewide traffic stop data. We also only identified 2 agencies with statistical disparities that warranted further analysis, unlike previous years where we had identified 10 or 11 in a single year and significant statewide disparities. So disparities are certainly trending in the right direction. Traffic enforcement is trending in the right direction. We have found that stops for hazardous and aggressive driving behaviors are starting to increase more than the equipment or administrative offenses outlined in this bill. It's interesting data point. I know a question Rep. Fishbein had asked earlier about data related to differences in enforcement, right? Jurisdictions that have stopped doing something, and if it improves the disparity, and what does that do to traffic safety? We've seen here in Connecticut that when police use the motor vehicle code to primarily focus on things that we know are killing people, hazardous and aggressive driving behaviors, there are little to no racial and ethnic disparities in the data. When they start to use the motor vehicle code to focus on other things, or in particular to use it maybe as a crime reduction strategy, there's a high crime neighborhood, we're going to saturate it with enforcement with hopes that we can search cars and find contraband, and that's how we'll solve the particular crime problem. We found in Connecticut a very low return on investment, meaning we don't find a lot of drugs, we don't find a lot of, right, the data tells us that the hit rate for those searches is very low. And it tends to drive a racial and ethnic disparity. And so I think the evidence in Connecticut has told us that when departments on their own have decided to pull back on the violations outlined in this bill, they're seeing positive outcomes, being, you know, reduced traffic crashes, reduced racial disparities, which will hopefully ultimately lead to increased trust between police and the communities that they serve.
Thank you for that. But I was specifically wondering, with the increase, was there an increase in the stops that we have outlined in this bill?
There were increases across the board in sheer numbers. So certainly we saw the number of stops for defective lighting or registration violations increase. But the good news is we have seen stops in other categories that are more closely related to hazardous and aggressive driving behaviors increase at a greater rate. And I think
And,
that's
and rightfully so. I have experienced those, especially folks running red lights in this state. Yeah, very dangerous and
Yes.
very scary. But thank you as always for coming before us and sharing your expertise. Thank you, Mr. Chair.
Further questions or comments? If not, Ken, thanks for being with us.
Thanks.
Vern Riddick will be next. Vern with us? No, okay. Anderson Curtis.
Good afternoon, Representative Staffstrom, ranking members of the Judiciary Committee and everybody else in the Judiciary Committee. My name is Anderson Curtis. I'm the Senior Policy Organizer for the American Civil Liberties Union of Connecticut. I'm writing to testify in support of House Bill 5324, an act establishing secondary traffic violations. I know you've already heard the data about equipment-related stops, so I don't want to repeat that. What I would like to tell the members of this committee is about my own experience as let's say, quote unquote, a senior Black man, a lifelong resident of Connecticut, a holder of a driver's license for the past 46 years. I'm also a person who's been impacted by the criminal legal system, pulled over by the police, arrested by the police, and only speaking from my experience. Since August 17, 2007, when I was discharged from prison into homelessness, I've earned an associate's degree in counseling, have had sporadic periods of employment due to my criminal record. Due to that inconsistent employment, even with my degree, even though I finished the educational requirements in 2009, I couldn't pay $800 until 2015 due to collateral consequences. Finally, in 2018, after being fired from 3 jobs, I started volunteering at Prison Fellowship as a reentry life coach at Rikers Island, commuting 11 hours for a 90-minute session with 2 men about to be released. I landed at the ACLU after Prison Fellowship. So for the past 6 years, I worked hard and enjoying the longest period of stability in my life. I've earned a pardon for the Connecticut Board of Pardons and Parole. And I wanted to share the periods of stability and some not so stable periods of my life with this committee, because while I was driving my registered and insured vehicle during my period of stability with my valid driver's license, I was pulled over in Vernon. The officer came over, asked my license and registration, and he told me I was not wearing my seatbelt. Before the officer left to go to his car to run my identification, I asked him if I was going to be okay. Due to all my cumulative traumas I've experienced from the arrests, incarcerations, for the time that officer's at his car checking me out with his lights flashing, my instinct overpowers, overrules, and overwhelms my logic. I believe I'm about to go back to jail. I take responsibility for who I am today. My parents, Albert and Rita Curtis, made sure I reconnected to the values that they raised me and my sisters with. And I'm testifying today to share my testimony that no one can lobby, legislate, or litigate my trauma away. I've testified to bring awareness of this trauma to the committee and strongly urge this committee to pass HB 5324. Thank you.
Thank you, Anderson. Representative Howard.
I don't have a question. I just want to thank you. We don't always agree on things, but I admire your rehabilitation. I admire the work you did and the hard work that you continue to do. And I say with great sincerity that I appreciate every conversation we have, and I'm grateful that you came today. Thank you.
Thank you.
Anderson, thank you.
All right.
Ann Hughes.
Thank you, Mr. Chair, and thank you to the Judiciary Committee. My name is Ann Hughes. I'm your state representative of the 135th House District. We had an exciting informational forum on the use of psilocybin here on January 10th. It was attended by a lot of expert testimonials from all across the country. So I'm here in support of prioritizing justice-centered measures in HB 5297, decriminalization of small amounts of psilocybin. Once again, we have a long history of criminalization of psychedelics here and the enforcement of legal penalties here in Connecticut and across the country. And even though psilocybin, as we've heard from multiple researchers and evidence-based experts, it is a non-addictive treatment, and it has been shown to be very safe and effective, especially in the therapeutic space for veterans dealing with PTSD and people with, intractable depression. We still treat it as a class 1, Schedule 1 substance, the most dangerous drug classification. This is a plant. This is a plant. And if this sounds familiar, once again, our science, our evidence-based perception of psilocybin has not updated to a justice-centered policy that really centers the awareness of how effective this can be, and especially treating folks that are really desperate for a non-addictive, therapeutic, supportive, clinical treatment of mental health issues that they haven't had access to. And I really want to prioritize those folks first. And I want to prioritize for once we get the justice-centered policy right. And that's why we need to prioritize patients, veterans, therapeutic supporters that are trained to support folks with these mental health issues that need access now, and we cannot be criminalizing folks. And we need to acknowledge the harm. I heard somebody say, is this really something that is necessary? Because how many times are you stopping people? There are people in our jails right now because of this policy. And we need to prioritize decriminalization first. We need to prioritize a justice-centered approach to updating our policy. So I hope that you take all that in mind and refer to the informational forum we had on January 10th here at the Capitol. Thanks.
Questions or comments? Questions or comments? Representative Howard?
Thank you, Mr. Chairman. Representative, thanks for being here.
Yeah.
I found online the form you did on, I confess I missed it. It's 3.5 hours. So I have a pointed question.
Okay.
Because I think we can both agree that trying to find 3.5 hours this time of year is difficult for all of us. But,
Yes.
was there any concern or any discussion around the use of it while driving? That's one of my major concerns when we talk about these things.
Yeah, definitely. We definitely had a whole bunch of clinical therapeutic supporter people that really talked about we don't want this to be like a
So if
rollout
I watch
of.
that, I'll get answers to that then.
Yeah, and we had multiple clinicians that really talked about having a very, very controlled, safe, effective therapeutic space that so that people were not driving under that influence, because it is a safety concern. It is a safety concern.
The big one.
Yep.
Yeah.
Yeah.
Thank you. Thank you, Mr. Chairman.
Further questions or comments? Further questions or comments? If not, Representative Hughes?
Thank you.
Thanks for being with us. Chris Burbank? Chris Burbank with us?
I'm working on it. I apologize. Thank you for allowing me to be here. Can you hear me?
Sure, go ahead.
My name is Chris Burbank. I'm the Law Enforcement Strategy Advisor at the Center for Policing Equity. I was with the Salt Lake City Police Department for 25 years, serving as chief for 9 years. I'm also a past vice president of the Major City Chiefs Organization, the 70 largest agencies in the United States and Canada. House Bill 5324 is a positive step for law enforcement to focus time and attention on traffic stops that are actually related to public safety. There are costs to every police interaction, both for the public and law enforcement. Low-level traffic stops do not improve safety. They do, however, have ancillary consequences. The role of law enforcement is to prevent crime and harm. We should educate people about driving instead of playing gotcha. Effective policing must be based on trust and legitimacy between law enforcement and the communities they serve. Black and brown people are disproportionately targeted for equipment and administrative violations, and these are used as tools for pretextual stops, which is simply wrong. House Bill 5324 is not a drastic change, but it is a change in the right direction. We can address racial disparities and other consequences of low-level enforcement. This bill isn't tying the hands of law enforcement or taking away a tool. For many of these low-level stops, officers aren't even writing tickets. In fact, the drivers drive away, still committing the violation. Officers have enough on their plate, and data show that stopping people for low-level offenses is not improving public safety. In New Haven, when the chief reprioritized traffic enforcement to focus on dangerous driving, the department reported equipment and administrative offenses were reduced by 6%. Accidents dropped by 10%, and crime dropped by 5%. In Hamden, police were using pretextual stops in a primarily Black neighborhood. After shifting enforcement tactics to focus on dangerous driving behaviors, they saw a 5% drop in crime. If there is reasonable suspicion, that is a basis to stop someone. This bill is not taking that away or limiting that. Also, these minor violations like single brake light or tail light out are not safety issues. It would still be a primary offense if you had no lights. But if just one light is out, you can still see the car, and that addresses the safety issue. According to NHTSA statistics, less than 1% of all crashes across the nation are caused by a single headlight out. None of the violations being considered by this bill contribute to crashes in Connecticut, as you've heard. As someone who's been on the front lines of law enforcement, I can say with confidence that this bill is common sense and will lead to better policing by allowing officers to focus on what really impacts public safety. Historically, the profession of policing has made two major mistakes: not utilizing statistical data and failing to believe with
Sir,
lived experience.
I don't know if you can hear the bell, but your time has expired. So if you could just finish your thought.
I'm finishing, thank you. Believe the lived experience of members of the public. You have the opportunity today to remedy this.
Thank you. Questions or comments from the committee? Seeing none, it's been with us. Terry Ricks.
Good afternoon, Representative Stastrom, all distinguished members of the committee. My name is Terry Ricks. I live in Hartford. I'm a smart justice leader with the ACLU of Connecticut. I am here to testify in support of House Bill 5381, an act concerning the use of police body worn recording equipment. I have to describe an experience I once had. It was a 90-degree day, a summer day. I was driving downtown Hartford with 3 friends on our way to the beach. We were pulled over by police for absolutely no reason. We were ordered out the car, told to lay down on the ground, and the officer started yelling at us. They kept us on the ground for about 10 minutes. It was so frustrating and embarrassing because we had done nothing wrong. There was no reason for the police to treat us in this way. Eventually, they released us and we were able to continue on with our day. The police had done that to embarrass us, to demonstrate power, to show that they had the upper hand. But how could I prove it without a body camera and the audio of what the police said to us? Another example was once when we were in my projects, which is a housing project called Sand on Main Street in the north end of Hartford. The police showed up on city buses, which they normally did to try to get information, slammed us all on our cars, handcuffed us, and set us on the curves like we were show dogs, to antagonize me with profanity and threats and demeaning insults. The police just allowed people to view us. It was an embarrassment thing. It wasn't about finding anything because they never found anything in these instances. It was just a show of power once again. This bill is important to me because if body cameras are truly going to be effective tools for oversight, transparency, and most importantly, trying to establish community trust, if that will ever be possible, they have to be paired with policies and procedures that accomplish those goals. Otherwise, the risk becoming just another surveillance device that records some things, but not all things. That's like writing a book with no narrative or a movie without a script. A story can't be told with eyesight alone. We can't understand the story without the voices. If you're not doing anything wrong, if it's being done by the book, why should it have to be done in secrecy? We should all be able to see and hear what is going on. Otherwise, we can only assume that something is being hidden. HB 5381 would require the police to review their training programs on the use of body cameras and recording equipment and to upload their guidelines to include the circumstances under which police officers shall not mute their body cameras. I support HB 5381 and urge the members of this committee to do the same. Any questions?
Thank you. Questions from the committee? Representative Porter?
Thank you, Mr. Chair. And I don't have any questions, Terry. I just want to really thank you for coming before us again and sharing. You know, I know this triggers trauma. It brings up things from the past. I know it's hard for you to do. I want to acknowledge that. And I want to thank you for having the courage to continue championing the rights of the people. And I want you to know it doesn't fall on deaf ears. We're listening and we're looking to get this right. So thank you again. And thank you, Mr. Chair.
Further questions or comments? Representative Osborne?
I just wanted to say thank you. Thank you for helping me to see this bill through your eyes today. Thank you for sharing.
I appreciate that. And that's all. I don't want it to fall on stony ground.
Thank you for educating me.
Appreciate you.
I do appreciate it.
Thank you.
Terry, thank you for being with us. Thanks for your advocacy.
Thank you, Representative Stafford.
Josiah Shalee? Josiah Shalee? Okay. Luis Mate?
Good afternoon, members of the committee. My name is Louis Mate Jr. I'm a smart justice leader with the ACLU. You feel that? That discomfort, the confusion, the uncertainty? See, I prepared a testimony in support of House Bill 5324, where I presented data to you probably read, rhetoric you've likely heard. You know, we can sit here and talk about how the inconvenience of minor traffic infraction can cost a struggling family their livelihood due to missed work days, as well as other contingent costs. We can converse about the injustice of using minor infractions as a probable cause tactic to search the vehicles of an uninformed and fearful populace. But none of that matters if you can't empathize with the trauma generations of militarized policing can wreak upon the psyche of Black and brown law-abiding citizens. If you've never been detained because you fit a description or been stopped and thrown against a wall for merely existing in your neighborhood, you don't know what the anxiety police presence creates. House Bill 5324, an act establishing secondary traffic violations, is a way to mitigate community trauma by reducing police interactions for infractions that do not present a danger to public safety. Why divert policing resources to matters that don't promote safety and wellness to our entire community? See, there's two sides to the safety issue this bill addresses. I believe it was Ken Barone earlier who presented recent data highlighting the rise in traffic stops over the past year in Connecticut. Social media is rife with videos of officers being hit by cars during traffic stops. One folded flag is far too many, is it not? So why further endanger them for nuisance stops such as a cracked taillight? In conclusion, I'm asking that House Bill 5324, that it's a bill that promotes the safety and wellness of our community as a whole. And as you vote on this bill, I urge each of you to sit with that tension, internalize that discomfort, because while being pulled over may be an inconvenience to you, to some of us, it could cost us our life and our livelihood. And one brief footnote, because there were questions asked about aggregate data, There was a study released by the University of South Carolina looking at traffic stops in the state of North Carolina over a 14-year period, and they found that Blacks were 63% more likely to be stopped, even though as a whole they drive 16% less. Taking into account less time on the road, Blacks were about 95% more likely to be stopped. Also, they were 115% more likely than whites to be searched in a traffic stop, despite contraband being found in whites' possession more than in Blacks. So with that, I just ask you to consider this bill, and I urge you to push it forward and support it. Thank you.
Thank you. Questions or comments from the committee? Senator Kissel?
Thank you very much, Chairman Staffstrom. I just want to compliment you on your public speaking skills. That pause in the beginning, it's a great method of presenting your point. And you actually brought it all the way to the end as well. And you highlighted a lot of the data too. So as much as I appreciate it, and I'm sure you heard earlier, the concerns raised by the Police Chiefs Association, and I understand where they're coming from. And we did change the bill last year to allow stops for rear turn signals or rear lights, because typically someone is not going to spot that if they're driving the vehicle. But, you know, unfortunately, there are communities, I don't think anyone up in North Central Connecticut for sure, but there's just tales where this is abused, whether intentionally or unintentionally, and thus the data shows disproportionate impact on people of color. So I appreciate your testimony, and you really did a great job.
Thank you, Senator Kissel. I appreciate that. And you see that many of those communities where this does happen, and they so-called find a reason, we end up in your district one way or another, right? Have a blessed day.
Folks, I know we're getting late, but I do have to just remind folks we can't clap, we can't cheer. Further questions or comments? If not, thank you, sir, for your testimony. Appreciate it. John Piscopo. Okay, Beth Hamilton. Okay. Olivia Rinks. She testified or she did? Okay. Got bad information then. Then I guess that it takes us to the end of our list. Thank you all for being here. We declare the public hearing closed. We will be back on Friday. Everybody can sleep in a little bit. We're not going to start till 11 on Friday, but 11 o'clock Friday hearing, and then we do we may vote depending on how long things go. We'll see how long the hearing goes. All right. See you all Friday.